Welcome, Your Excellencies, honored guests, participants, sponsors, and speakers to this 6th Annual Legal Plus Arbitration Summit, this one virtually. I am Victor Leginsky, Independent Chartered Arbitrator, and I'm honored to be speaking with you today wherever you are, whatever your time zone. Of course, we cannot begin without acknowledging the terrible toll that the COVID-19 pandemic has taken on people, for some, on their family and friends throughout the world. While we wish it were otherwise, we have to meet virtually for this summit. I have taken part in most of the excellent events in Qatar, organized so expertly by Jason and Bettina of Legal Plus, and I do miss receiving the excellent Qatari hospitality that I always get at these events. Those of us involved in arbitration and dispute resolution have always been innovative, flexible, and able to deal with ambiguity. Now, we have to demonstrate these qualities even more. Many companies which traditionally use arbitration have seen a drastic reduction in payments due to pandemic-related or low oil price issues. Governments have to deal with greatly increased service requirements and reduced revenues. And yet, disputes continue to arise, with delay-related disputes on the increase. However, to my point about being innovative and flexible, we have also rapidly changed the way we arbitrate. We are all comfortable with online hearings and web-based meetings. Arbitration centers and courts have taken it to the next level and quickly improved the way they register and administer cases and work remotely. I, for my part, am extremely proud of the way parties, counsel, both in-house and external, arbitration center and court personnel, and arbitrators and judges have been able to innovate, learn, and improve efficiency in the face of this global crisis. And today, we will hear from the creme de la creme of court officials, experts, counsel, and arbitrators on the many ways we are revolutionizing the conduct and funding of alternate dispute resolution. One note before we begin: if any of you have any questions to ask, please ask them on the text box to the right, and the speakers will come back to them. We wish to encourage your participation so you can get the most out of this session. Now, I am very pleased to hand over to Christopher Grout, who will provide the opening address. Christopher holds an LLB in law and an LLM in canon law, and was called to the bar of England and Wales in 2007. He has been registrar of the Qatar International Court and Dispute Resolution Committee, the QICDRC, since 2012, and sits as a deputy district judge in England and Wales, exercising a broad civil and family law jurisdiction. He will speak on the role of the QICDRC and also give us an update on mediation. Christopher, over to you.
Well, thank you very much, Victor, for that kind introduction, and it's nice to see you, albeit virtually. And good morning to everyone from Qatar, or good afternoon or good evening, depending upon where in the world you might be watching this from. It is a great pleasure to be giving the opening address at the Legal Plus Qatar and MENA 6th Annual International Arbitration Virtual Summit. We have all by now become very familiar with hosting and attending events virtually. But even so, it is worth acknowledging the work that Jason, Bettina, and others at Legal Plus have put into ensuring that this summit can go ahead, albeit via a different medium from what most of us would in the past have considered desirable. But of course, those ways of operating are no longer viable, at least at present, and we've all had to adapt in order to continue with our work and life in general. The conduct of arbitrations and other forms of dispute resolution are no exception to that rule. Across the world, courts, arbitral institutions, and other dispute resolution centers have had to modify their working practices in order to ensure that cases can continue to be heard and disputes can be resolved. Some have achieved much greater success than others in this regard, and you will doubtless all have your stories to tell, for better or worse. The important thing, however, is that most bodies, certainly here in Qatar, that are tasked with resolving disputes were quick to implement procedures in order to ensure, so far as possible, that parties to disputes were not denied access to justice, in whatever form that might take, depending upon the nature of the dispute at hand. A good example of this can be seen from the measures the Qatar International Court put in place as soon as the pandemic hit. It was important both for the court and its users that there should be no unnecessary downtime as a result of the impact of COVID-19. Case hearings immediately moved to an online format, allowing all court users, whether they be litigants, lawyers, staff, or judges, to appear in court remotely from their homes or offices, thus ensuring that cases were able to continue as planned, without, of course, endangering the safety or security of those involved. Moreover, the court's specially designed e-court system allowed users to file and serve their pleadings electronically, as well as receive and respond to communications from the court. Although the staff have now physically returned to the court, these measures otherwise remain in place, with all matters relating to the court being conducted electronically and online. This approach ensures the continued well-being of all involved in the litigation process, whilst also making sure that cases are heard and determined in a timely manner without unnecessary delay. The programme today is, as always, an interesting one. The first grand panel, which follows this opening address, will be looking at the extent to which arbitrations can be conducted quickly and fairly, a vitally important consideration at any time, but most especially now, when disputes need to be resolved without delay, not only because that is what parties expect, but because courts and other dispute resolution centres cannot risk cases becoming backlogged on account of not having the technological means to hear and determine cases during the time of COVID-19. After that, you will hear about funding options for international arbitration, followed by a presentation from my colleague, Dr. Zain Al-Shara, on the arbitration regime here in Qatar, with emphasis on the specific role played by the Qatar International Court in supporting the arbitral process. There then follows an interesting piece on expert evidence in arbitration, followed by a concluding panel discussion on that ever-important topic of enforcement. What I would like to do in the time remaining to me is to talk about a form of dispute resolution that complements arbitration and litigation, namely mediation. In 2020, the Qatar International Court and Dispute Resolution Centre launched its new mediation service. As you will all be aware, mediation is a voluntary process which involves an independent third party who helps the parties reach an amicable settlement in respect of their dispute. Mediations are conducted in private and are, generally speaking, considerably quicker and less expensive than arbitration or litigation. Providing that the parties agree to participate in the process, mediation is capable of resolving a wide range of different types of dispute, including, but not limited to, disputes between employees and employers, consumers and traders, as well as businesses and those they engage. Unlike arbitration and litigation, mediation is not an adversarial process. Instead, the mediator facilitates discussion and dialogue between the parties, with a view to reaching an agreed decision. This has the advantage, in many cases, of preserving the relationship between the parties, something which inevitably cannot be achieved where parties resort to arbitration or litigation. At the QICDRC, mediations are conducted in accordance with the QICDRC mediation rules, which are available on the QICDRC website. Mediation at the QICDRC is initiated in one of three ways. First, by the Qatar International Court or the Qatar Financial Centre Regulatory Tribunal, with the agreement of the parties. Secondly, as a result of a contractual provision to refer the dispute to mediation. Or thirdly, at the voluntary request of one or more parties to a dispute, with the agreement of the other party or parties involved. The QICDRC has established a panel of local and international mediators, which will soon be published on the QICDRC website. Between them, the mediators have substantial experience across a broad range of areas, including, importantly, within the construction industry. Where parties seek to refer a dispute to mediation, the registrar will suggest a list of mediators from the panel, from which the parties can make a selection. If the parties are unable to agree on a particular mediator, the registrar will make the appointment for them. Insofar as fees are concerned, at present the QICDRC does not charge an administration fee in respect of mediations conducted in accordance with its rules. Where the mediation arises by virtue of a referral from the Qatar International Court or QFC Regulatory Tribunal, the fees of the appointed mediator will be borne by the QICDRC. In all other cases, the fees payable to the mediator and the manner in which they are to be paid are to be agreed between the parties and the appointed mediator prior to the commencement of the mediation. In accordance with the QICDRC mediation rules, the appointed mediator has complete flexibility to conduct the mediation in such manner as he or she considers appropriate and most likely to be successful, having regard to the nature and circumstances of the dispute. Of course, during these times of COVID-19, mediators will, where possible, be making full use of the QICDRC virtual hearing capabilities to ensure that mediations can take place safely and securely. Ideally, the mediation will result in an amicable settlement agreement, which all parties are content with. If settlement cannot be reached, the parties may of course then consider whether to resort to another form of dispute resolution, which will most probably be arbitration or litigation. Parties who wish to refer a dispute to mediation at the QICDRC should, having read the relevant mediation rules, complete the request for mediation form, which is again available on the website, and return the completed form to the registry by email. In addition, you will find on the QICDRC website a template mediation agreement, which sets out the suggested terms upon which the parties and the mediator agree. It covers important matters, such as the conduct of the mediation, confidentiality, costs, exclusion of liability, and law and jurisdiction. It is important, however, that the parties tailor the agreement to meet their individual needs, especially in relation to applicable laws and the jurisdiction of courts. It is very much hoped that those doing business in Qatar will consider mediation as a viable form of alternative dispute resolution, and will accordingly agree to refer disputes to the service. A final topic, and in my view one of the most important topics, I would like to address is the desirability that those, particularly within the legal profession, devote some time, especially in these difficult circumstances, to helping people who are in greatest need. Last year, in recognition of the struggles faced by many in light of the pandemic, the Qatar International Court and Dispute Resolution Centre launched its pro bono service. This service enables individuals who fall within its scope to receive legal advice, assistance, and representation at no cost. At the QICDRC, pro bono legal advice and representation is provided by lawyers who volunteer their time and expertise to assist individuals with limited financial means in regard to civil and commercial disputes, regulatory appeals, or other legal issues that fall within the jurisdiction of the Qatar International Court or the Qatar Financial Centre Regulatory Tribunal. Individuals and small companies who are seeking pro bono assistance should refer to the QICDRC pro bono service guidelines and complete the application for pro bono legal assistance. In particular, those who are seeking pro bono assistance must note that, under the service, lawyers can only provide advice and representation in relation to matters which fall within the jurisdiction of the court or regulatory tribunal. Also, the service is only open to those who genuinely cannot afford to instruct a lawyer, and so as part of the application process, applicants will be required to disclose information about their financial position and provide evidence and support. As to volunteering with the QICDRC pro bono service, this is beneficial not only to those who are in need of legal support, but also to the legal profession as a whole. Providing advice and representation in relation to disputes which fall within the jurisdiction of either the court or the regulatory tribunal can be both a challenging and rewarding experience, which has a positive impact on both the professional development of individual lawyers and the firm's relationship with the QFC community and those who interact with it. My plea to the legal community in Qatar, as well as further afield, is therefore to consider donating some of your time to assist with the service, and to please get in touch if you would like to do so. I would also like to take the opportunity to thank those lawyers who have so far joined the service, as well as the team of academics and students at Hamad bin Khalifa University's College of Law, who have kindly agreed to devote time providing research support to lawyers and others in appropriate cases. In bringing this opening address to a close, I would like to end by simply wishing you all an enjoyable virtual conference and my very best wishes for 2021. Thank you.
Thanks very much, Christopher, on the innovative and forward-thinking ways QICDRC is making justice and dispute resolution both efficient and accessible for Qatar and internationally as well. Thanks also for the interesting update on mediation, an ADR technique that I'm sure will grow in the region. So thanks for that update as well. It is now my very great pleasure to introduce the first grand panel, which will present us with the latest in approaches in efficiency and expedition. This panel is chaired by Jay Alexander. Jay chairs Baker Bott's global international arbitration practice. He is based in London and has arbitrated cases throughout the world. During the past several decades, Jay has served as counsel or arbitrator in international arbitrations with total amounts in dispute of more than 125 billion US dollars. Jay has made many trips to Doha to serve his clients and is looking forward to a time, as we all are, in the not so too distant future, when he will be able to travel back again to see his friends and colleagues. The panel Jay is moderating focuses on how disputes can be resolved both quickly and fairly. Jay?
Thank you, Victor. Good morning to all. I'm here today with a wonderfully talented panel, Danya Faz and Matthew Walker. Danya is the Deputy Director of the ICC's Middle East and North Africa Representative Office, based here in the Persian Gulf. She has a remarkable history as an in-house counsel, as an external lawyer at a law firm in the region, and she's a lecturer at the American University of Beirut, as well as St. Joseph University. She's a certified CEDR mediator and will have a lot of valuable contributions to our discussion today. Matthew Walker is a partner in both the Doha and London offices of K&L Gates. He practices in the areas of construction law and dispute resolution, acts as advocate and counsel in arbitrations in Qatar and throughout the region under many institutional rules, including the ICC, the SIAC, and the QICCA. He also sits as an arbitrator and has appeared before the Appellate Division of the Qatar International Court and the Qatar Court of First Instance. He's a fellow of the Chartered Institute of Arbitrators and a fellow of the Chartered Institute of Building. He's the honorary secretary of the Qatar and QFC branch of the CIARB, and is also an accredited mediator. We thank you very much for coming today. We wish this were a live presentation where we could chat and talk and take your questions live. Because that's not possible in the current environment, we do invite you to reach out to all three of us with any questions or follow-up you may have. I'd like to begin with a brief introduction, and then we'll turn to a sort of a question and answer session, which I think will be most interesting for everyone. We're all familiar with the maxim, justice too long delayed or too expensive is justice denied. One of the virtues or desired virtues of arbitration is the ability to resolve disputes relatively speedily and efficiently. But we can all tell stories, you in the audience and us here on the panel, of arbitrations that have gone on for years and years and years and years. Why is that? There are many reasons for that. And sometimes it's because the case is extremely complicated. A detailed, complex construction dispute, for example. But often it's because one side wants delay, typically a respondent, but not always. Sometimes it's because counsel, both counsel, are looking to nail down every last corner of their case and avoid any potential risk or doubt or uncertainty. And sometimes it's because arbitrators are afraid to say no to process, afraid that their award might be annulled if they deny either party anything that party asks. In sum, it's fear of uncertainty. Arbitral institutions have responded to that fear. They have done so by amending their rules, both to provide for expedited arbitration proceedings and to provide for emergency arbitrator rules. And we'll talk about those today. In addition, parties can resolve the impasse of delay through mediation, and we'll try to get to some of the topics about mediation as well. There are, of course, many other options for expediting a dispute resolution. You may have heard of IBM's Watson, a computer program that purports to be able to take all the input of all the information and make decisions. I suspect we're still a little ways off from that being effective or something that anybody is going to put their case to, but it is the future, or it may be anyway. Until then, however, we need thoughtful and courageous lawyers. And for that, we have Matthew and Daniel. So let's start with some questions. Daniel, we'll begin by talking about expedited arbitration. And since you've now been at the ICC for several years, maybe you can talk to us a little bit about how the ICC's expedited arbitration rules work. Please.
Thank you, Jay, for the generous introduction. It's a privilege and an honor to be here today and to be part of this discussion. I do really look forward to this roundtable. And thank you also for Legal Plus for inviting us. Our International Arbitration Summit in Qatar used to be an annual tradition every year. Unfortunately, this year we're not able to meet physically, but we're trying to make up for it through this virtual platform. As Jay mentioned rightfully, the concerns that were raised by many users regarding the cost efficiency of the arbitral proceedings were actually what the main driver behind many arbitral institutions over the past years having introduced expedited proceedings. As actually we know, a speedy process, a flexible, speedy, and cost-efficient process were seen as the inherent features of arbitration historically. However, the recent practice have unfortunately showed us the opposite. And surveys like the Queen Mary University Survey on International Arbitration showed that many actually users do not foresee cost efficiency as one of the main advantages of arbitration. To address these legitimate concerns, amendments were introduced in the ICC rules in its version of March 2017, where the EPP provisions, the expedited provisions proceedings, were introduced. I will just give an overview regarding the scope of these provisions and how do they apply in practice. First, regarding the scope, these provisions will apply by operation of the rules, which means automatically, to all arbitration agreements entered into on or after the 1st of March 2017, and provided that the amount of the dispute does not exceed 2 million USD. However, here I have to add an update, a very recent fresh update. Since January this year, with the entry into force of the 2021 version of the ICC rules, this threshold has actually been increased to 3 million USD dollars. And this actually reflects, as I will be tackling on later on, the popularity and the fact that these actually proceedings were suitable to the needs of the users. The main differences between an expedited procedure and the procedure under the regular ICC rules is that it will be actually referred to one sole arbitrator regardless of any agreement to the contrary by the parties. So far, the agreement of the parties on the number of the appointed arbitrators or the procedure governing such appointment prevailed on the ICC default rule of one arbitrator. For the expedited procedure, it will always be one sole arbitrator hearing and ruling on the case, regardless of any contrary agreement. There is a control that is recognized to the arbitrator in managing the process. The arbitrator can decide to limit the length of the submissions, the evidentiary submissions, can decide to rule only upon the written submissions, can decide not to hold any evidentiary hearings, expert or witness testimonies. All this to ensure that the process is expeditiously resolved within a timeline of 6 months. 6 months as of the case management conference. Another feature that is distinctive of the expedited procedure is that there will not be what we call, and what is actually an institution of the ICC rules, the terms of reference. The terms of reference are not required under the expedited procedure, and the timeline will start from the case management conference that should be held within 15 days from the saisine of the arbitral tribunal, to ensure that within 6 months an award would be rendered by the arbitrator. So it's a streamlined process handled by one arbitrator within a limited timeline. One feature was maintained, which is the signature feature of the ICC rules, scrutiny. The award issued under the expedited procedure will be scrutinized by the court. This was actually a debate topic in 2017 when the expedited procedure was introduced, and question was raised whether we maintain the scrutiny or we waive the scrutiny for this expedited procedure. And the decision, rightfully so, was to maintain the scrutiny and not to jeopardize in any event on the quality of the award. So expedited, yes, but not at the expense of the controlled process that is exercised by the court on the award. Another also amendment that was introduced in 2017 and has been applied so far is the financial implications introduced in the note to parties and arbitral tribunals in case of delays. And this actually was applied in practice when there is a delay by the arbitrator, a delay that is unjustified by the circumstances. There will be financial implications and a reduction in the arbitrator's fees. The same financial implications will apply to the court in case there is a delay in the scrutiny process that is also now should be done within a reduced time limit. And finally, the scale of fees for the arbitrators is a reduced one. It's around 20% of reduction in the fees when we engage in an expedited arbitration procedure compared to a regular procedure under the ICC rules. So this is in a nutshell an overview of the scope of the EPP. And later on, we'll be touching on some figures that would actually reflect how in practice these provisions have played out so far.
Have a vested interest in the ICC rules, it would be remiss not to say that some of the other institutions have either followed your lead or joined you in adopting similar sets of expedited rules, like the LCIA, the Singapore Institution, and a number of others. But that's wonderful. Thank you. Matthew, does increased speed mean inadequate process? Or to put the question another way, do we need 1,000-page memorials, discovery, and 2-week hearings in every case?
Much for that question, and let me first of all join Danya's thanks to you and to Legal Plus Asia for your kind words and for making today's seminar possible. Obviously, we're sad not to be in Doha. I did happen to be there a couple of weeks ago, so I know what a lovely time of year February is to be in Doha. But I'm joining you from a cold and wet London. Jay, before I get on to the topic of process, if you like, I looked at the question of how should we run an expedited arbitration procedure. But before that, I think there's almost a gateway threshold question that we should touch on briefly, which is can we? Can we in different jurisdictions, and how do jurisdictional rules, how does the law of the seat impact upon the ability of the expedited procedure to go ahead? I just thought it was worth touching on it, because I was kind of turning, if you like, that pebble over in my mind as to what would be the attitude of the Qatari courts and also the Qatar International Court to an expedited procedure taking place and to an award taking place. Because I think it's fair to say, I don't think we have seen a massive track record of those types of cases happening yet in Qatar. I think the judgments that I was looking at, there's I think quite a well-known one from the Shanghai Court number 1. It's a case called Noble Resources and Shanghai Good Credit, and that's from 2016. So that was an interesting one where the parties had agreed, in that particular instance, it was the SIAC rules that applied to the particular arbitration, and the parties had agreed that there would be an arbitral tribunal of 3 arbitrators. However, then an application was made for an expedited arbitration provision. SIAC appointed a sole arbitrator under the SIAC rules, because like with the ICC, when it's an expedited provision, you go for a sole arbitrator. And in that particular instance, the Shanghai court refused to enforce the award on the basis that the arbitral agreement had provided for 3 arbitrators, but then SIAC had proceeded to appoint only 1. So that got me thinking, is that a risk in a jurisdiction like Qatar? Certainly, one of the threshold grounds for an application to resist recognition of the award under Law 2 of 2017 would be under Article 33(2)(d) of the law, where if there is a discrepancy between the number of arbitrators that the parties agreed upon and the number of arbitrators who heard the dispute, that would be one of the grounds for challenging. So if you like, that's the downside. The upside is, we've seen in other jurisdictions that actually the courts take a more pro-arbitration, a more purposive view of how to look at parties' agreements. So, that particular case, there's one called AQZ and ARA, and that's from 2015 and in the Singapore High Court. And in that particular instance, again, another SIAC arbitration clause. And in that instance, the court said, well, because the parties have agreed to adopt the SIAC rules, that it is up to SIAC to determine the number of arbitrators that would be appropriate to a particular hearing, notwithstanding whatever the parties' agreement may say. The $64,000 question, I suppose, is where do I think that the Qatari courts would go? It's difficult to know, but my hunch, and it's only a hunch, but my hunch is that the Qatari courts would probably lean a bit more towards the sort of the purposive, the supporting arbitration end of the spectrum. Certainly, judgments that we have seen coming through the Qatari courts recently would suggest that the Qatari courts are very eager to support the process of arbitration. They get arbitration. They're beginning to understand it as a means for resolving disputes, and so perhaps that should give us some hope and comfort as to expedited arbitration provisions being upheld and observed by the local courts. So that perhaps answers a little bit the question of, can we have expedited arbitration procedures? The next question then, the one you actually asked me, was, should we? And the answer is, I think almost we come full circle to where you started this sort of topic, which is, it's that concept which I think came from Sir Michael Latham's report that looked at the dispute resolution in England. Justice delayed is justice denied. Certainly, I remember that from Latham's report, Constructing the Team, which was back in the mid-90s, when it looked at that question of what was the problem with dispute resolution of large construction disputes in the UK, and that was a large part of it. And of course, in the UK, as we know, that then prompted construction adjudication as this sort of very fast-track system for the resolution of construction disputes in the UK. I think on balance, I come down on the side that essentially you're weighing up, aren't you, two different assaults on due process. One is, if you like, that the approach of due process in terms of lawyers wanting to ensure that they've argued every last potential argument in order to support their client's case. But then there is that broader question of due process, which is if I can't get a judgment, if I can't get a decision quickly from the person who is supposed to be hearing my dispute, then that is essentially a total failure of due process. If I can't get an award because I'm, 5, 6, 7, 8, I've got a current case, unfortunately, dare I say it, 9 years after it was filed, in that case, in a sense, it doesn't matter almost the quality of the arguments being heard, because they're 9 years down the road in a dispute, having already sort of foregone their fees for, I think, 18 months even before that particular piece of litigation started. So, there's a case where they've had no judgment for 10.5 years, and I'm not yet aware of the case that is of sufficient complexity that it warrants that level of delay in a judgment being rendered just because an argument needs to be heard. So I think I would come down on the side of, yes, you can and you should support these types of expedited procedure on the simple grounds, as we now say in the UK, that rough justice is better than no justice. And so I think, I would tend to suggest, yes, let's adopt expedited procedures for the right cases. I think, as you pointed out, not every case can be heard quickly. Not every case is easily understandable and can sensibly be resolved in a 6-month period. So it's about drawing the right boundaries. I certainly think that the ICC has got the test right in saying, cases of 3 million USD and under, there should almost be an assumption that you could hear those in a relatively fast-track forum, in a relatively fast-track way, granting the arbitrator sufficient and wide-ranging powers to set the procedure in order to ensure that you are striking that balance between hearing the parties and ensuring the right to be heard and ensuring the rights of natural justice, but also on the same side, not denying justice, not delaying justice and thereby denying justice. So that's probably how I would look at it.
How have users liked or not liked the expedited proceedings, and is the ICC seeing situations where users ask to be included even though their dispute is more than $3 million, or alternatively have users with smaller disputes under $3 million asked to be excluded?
Thank you. Absolutely, Jay. As I mentioned earlier, the expedited provisions apply either by operation of the rules automatically or on a basis of opt-in and opt-out by the parties. So the consent of the parties remain actually, as for any arbitration process, it's a consensual process in essence, and this will remain valid for the EPP procedure. The figures actually that we have in the recent updates reflect the needs and the suitability and the success actually of this procedure among the users. As we've seen many cases being submitted to the ICC Secretariat based on an opt-in option for amounts that increase the threshold by the operation of the rules, and also for contracts that were signed prior to the threshold date of 1st of March 2017. And just at the outset, and in line with what just was mentioned by Matthew, it is true that rough justice is better than justice denied, but this is, as he mentioned, rightfully depending on the circumstances of the case. And this is the approach of the ICC. The expedited procedure will apply when the scope and the conditions for application are met. But however, the ICC court maintains the possibility to, at any point of the process, to preserve the due process and to preserve the integrity of the arbitration proceedings, to switch from the expedited procedure to a regular procedure if need be. And this is to allow actually the parties to present their evidence to the fullest possible extent and to preserve the integrity and the due process. So we always need to keep this in mind and to balance between these two interests. And the ICC rules actually account for that. And there is flexibility. And we've seen it in some cases where the case can start as an expedited case, but in light of the circumstances, there will be a better justice served if we go under the regular rules. Now, in terms of statistics, if we look at 2017, 32% of the cases registered were involving an amount not exceeding 2 million. So actually, it was an opt-in basis, 32%. Of the 46 opt-in requests filed, 12 were agreed by the other party. In 2018, 96 opt-in requests were filed, and 22 were agreed by the other party. And there was only one opt-out from an expedited procedure in one case in 2018. In 2019, as of the end of 2019, we had 146 cases that had been or were conducted under the EPP. And of the 50 opt-in requests, 21 were agreed by the other party. So we see there is a good, decent proportion of opt-in submissions. And most of them are, at least more than half of them, were agreed by the other party.
But we should probably move on to emergency arbitrators. And just to sort of tee off the topic a little bit, even expedited arbitrations sometimes aren't fast enough when you have an emergency situation. If a counterparty is about to sell off an asset that you're entitled to a third party, or is about to destroy documents, or situations where you need immediate relief, historically, parties would go to the national court to get an order, an injunction, or a temporary restraining order, and that has certain advantages and certain speed to it. But the institutions, again, have responded to this by adopting emergency arbitrator rules. And so, Danya, maybe again you can start by kicking us off with an explanation of how the ICC emergency arbitrator rules work and your views.
With pleasure. Thank you, Jay. Well, regarding the emergency arbitrator, the response came earlier than the expedited procedure. It goes back to 2012, when the emergency arbitrator provisions were introduced in the ICC rules. Bearing in mind, actually, that it was not the first time that the ICC introduces a pre-arbitral procedure. The pre-arbitral referee existed well before 2012, but it was on an opt-in basis, and in practice, rarely were the cases where it was actually been applied. As you mentioned, Jay, absent such provisions in the institutional rules, parties would have only two options: either to go to a state court and seek an interim or a conservatory measure, or to wait until the constitution of the arbitral tribunal, which, as we know, sometimes can take much longer than expected. So these provisions actually, and they were also adopted by other arbitral institutions than the ICC, were intended to fill a gap out there. And we always see also a concurrent jurisdiction here. It will not be an exclusive jurisdiction to an arbitrator, knowing that in some circumstances a third party might be involved, and for an ex parte request, the state court will always remain the point of reference for the users. However, in many other circumstances, and in the presence of an arbitration dispute resolution clause, this avenue actually is much appreciated. The provisions were introduced in the Appendix 6 of the rules and at Article 29. These provisions, the intent actually, as I mentioned, is to fill a gap, to fill this void, and to allow for the user seeking an interim relief that cannot wait for the constitution of the arbitral tribunal to submit its request and to request the appointment of an emergency arbitrator. If we can make some observations that were drawn from the report of the ICC Commission and ADR on the emergency arbitrator proceedings, which is available actually on the website, we can make three main observations. First observation is that there is no prescriptive rule and no universal approach to the standards, being substantive or procedural standards for this procedure, and to determining the threshold. So there is great room of flexibility given to the emergency arbitrator in that respect. A second observation is that in a rare minority of cases, actually a relief was granted. And this doesn't come as a surprise, since it is an exceptional relief being sought in such circumstances. And the third observation that we draw from the analysis of the cases, we see that the emergency arbitrator has been applying a very important threshold and a key requirement, which is provided for at Article 29 of the rules, that the relief being sought cannot wait until the constitution of the arbitral tribunal. And here we have a sort of a determination of a threshold that is part of the admissibility and which falls also in the assessment of the substantive conditions during an emergency arbitrator proceedings. Now, if I can share maybe with you a little bit how the process goes on in practice. There is a role recognized to the president of the ICC rules at the very beginning of this process. And similarly, other institutions also has provided for this screening step that belongs to the president of the institution. I believe Hong Kong and SIAC also have the same screening process. And this is what we call the applicability test that is provided for at Article 29 of the ICC rules. This applicability test is actually a test of to verify the scope based on the content of the application. In the majority of the cases, most of the cases, the president will move forward with the request for an emergency arbitrator, subject to the final determination by the emergency arbitrator of the applicability test. The applicability test is a checklist of scope and the existence of the arbitration agreement. The signatory parties are allowed to submit for request for an emergency arbitrator. The arbitration agreement should be signed on or after 1 of January 2012, and the emergency arbitrator provisions will not apply if the parties have opted out, and it will not apply if the parties have provided for another pre-arbitral procedure other than the emergency arbitrator under the ICC rules. So this is the checklist, actually. It's a very high-level assessment, prima facie, done by the president of the ICC rules, and a determination that will be also down the line undertaken again by the emergency arbitrator as per the ICC rules and the appendix. Article 6, paragraph 1, provides for the authority of the emergency arbitrator to rule on its jurisdiction, but also to conduct the applicability test on the grounds of Article 29, paragraph 5 and 6, which actually set out the criterion that I just explained now. So this is in a nutshell how it starts. Obviously, during the procedure of once the emergency arbitrator is appointed, there will be, in addition to the admissibility test, the applicability test, and some jurisdictional challenge that will be raised. And here we see that the frontier between admissibility, jurisdictional, and applicability can be a bit blurry, and sometimes there would be some overlapping. mainly when jurisdictional challenges are being raised by the respondent. In terms of jurisdictional challenges that were raised in ICC cases under emergency arbitration rules, some were based on the existence of a multi-tiered clause, the date of the agreement, the non-signatory, the standing, the authority of the emergency arbitrator, or the scope of the relief. These are some of the jurisdictional challenges that were raised. There is no deadline under the emergency arbitrator provisions to raise such challenges. However, the ICC court invites the parties and the emergency arbitrator to raise those challenges at the earliest, given the time limits of this procedure, and to give the emergency arbitrator the possibility to rule early on to the fullest possible extent on these grounds. I will not dwell on the substantive standards, maybe later on, as this will relate more to the determination by the arbitrator of the different substantive standards based on the content of the application and the circumstances of the application. But I will leave this for the next question.
Can you give us some examples of when it's appropriate to seek emergency arbitrator relief and the strategic considerations that go into deciding whether to seek emergency arbitrator relief or perhaps go to a national court? Thank you.
Yes, and thank you, Jay. So when I was thinking about this question again, I sort of, if you like, I set myself that threshold question of what are the laws governing the jurisdiction and the use of emergency arbitrators. One case I thought was particularly interesting in England, a case called Gerard, Metals and Timmis, a decision of then Mr. Justice Leggett in 2016. And in that particular instance, he ruled that parties should not be going to the court to seek interim relief from the court, and there it was the usual sorts of interim relief that you might seek from an emergency arbitrator under Article 44 of the Section 44 of the Arbitration Act 1996 in England. And instead he said, look, if either if the tribunal is there or if the parties have agreed emergency arbitrator provisions, that you should be using those and not going to the court in that instance. I tried to work out whether and what would be the attitude of the Qatari courts to such an application. I think it's difficult to know. Certainly, this is an area where I do have sort of experience of what happens in practice, and although Article 17 of the arbitration law, the Qatari Arbitration Law Number 2 2017, although Article 17 assumes that the tribunal will be making those, giving all of those normal types of interim relief that you would ordinarily expect, at least most of them, and there are a couple that do fall outside even the aegis of the tribunal. There is an earlier provision of the arbitration law, which is Article 9, and that law, Article 9 of the law, does assume that if a tribunal has not yet been appointed, then the parties do automatically have the right to go to the local court. And so it seems to me that if that's going to be that threshold question of, you know, should we be appointing an emergency arbitrator, or should we be going to the local court? I think most of the time you will find that parties in a jurisdiction like Qatar will probably err on the side of caution and think to themselves, well, I'm going to rather go to the local court, simply because of, if you like, it is a more simplified, it's a more tried and tested route, in particular for the types of relief that a party might be looking to get at an early stage, particularly, you know, if you're going to take some quite aggressive steps to, if you're a respondent, to try and head off elements of the case. I'm thinking, for instance, things like travel bans. I'm thinking things like injunctions against performance bonds. I'm thinking of freezing of bank accounts. actually, one experience I have of that is as a claimant, where it was before the tribunal had been appointed, and so we were faced with that, that quandary. Well, what do we do in order to get the main contractor's attention? I was acting for the subcontractor, and I think in that instance we did go to the local court. We got the main contractor's bank account frozen, and I've never seen somebody respond so quickly after that. So oftentimes you're going to end up looking at those slightly sort of weightier questions of exactly how effective are the remedies going to be, and how tried and tested is it? And I think that is an issue where, at least in an emergency arbitrator context, where people are going to be perhaps taking that decision, well, no, maybe I'm going to be better off going to a local court rather than to an emergency arbitrator. I would add one additional aspect, though, actually, that may make you think the other way, which is it really depends, doesn't it, on your counterparty. And it depends on your counterparty, and in particular where you want the remedies to be enforced. If you're dealing with a counterparty that has got, if you like, potentially some documents in one jurisdiction and then some documents in a different jurisdiction, that's the point at which, frankly, you may the balance may go the other side, and you may think, well, okay, if I can get an emergency arbitrator appointed, and if I can get a very quick decision on, let's say, the freezing of documents, the retention of evidence, or the non-sale of a particular type of asset or share, and it's in multiple jurisdictions, then perhaps an award of an emergency arbitrator may be more effective in those circumstances. So that perhaps that's ultimately where I think you would end up. You'd be looking at
to go, and this is where, if we were live, I would poll the audience whether they want to continue with this topic or move on to the next. But since we can, I'm going to make an executive decision, and since we have two certified mediators with us, move really quickly to the mediation topic, and just ask you both, in your experience, when is the best time to try to mediate a dispute? And does it depend on the nature of the dispute? John, you maybe go first.
Yes. Well, in my opinion, Jay, it's always a good time to start a mediation. If we think that it's always a good time to start negotiation. So if you don't outrule negotiations, you shouldn't outrule mediation, because mediation is actually having someone, a third party, a facilitator, coming in and facilitating the negotiation process between the parties to enable them to find a settlement down the line. So it's always worth a shot. Now, obviously, it will depend sometimes, yes, on the nature of the dispute, but less than the nature of the dispute, because it can be a very complex dispute and mediation can be a very suitable means of resolution. It depends more on the attitude and the willingness of the parties and the stakeholders involved. If you have the direct stakeholders involved in the process, if you have the willingness to negotiate, to do some disclosure around the underlying interest, then you pave the way for a successful mediation down the line. This is in my opinion. I don't know if Matthew shares the same opinion.
Matthew, we can't hear you, I'm afraid.
Now, if I'm speaking, is that any better? Oh no. Is that working now?
Very remote.
Very remote. If I speak loudly,
Shout.
now.
Yes.
I'll try and shout. So I think my answer would be, if you know the story Goldilocks and the Three Bears, I take the baby bear approach. Not too early, not too late. You want to go for it when it's just right. I do think I've certainly had experience of cases where parties have talked about mediation, and then it's become painfully obvious that it's just too early, that in a sense the parties haven't really fully grasped with the parameters of the dispute, about what it is that's really an issue between them, about where perhaps in particular respondent just hasn't sufficiently engaged with the claim that the claimant wants to make. And I think in those circumstances, mediation, in my experience, isn't that effective. The too late, it's actually very seldom too late. I've had mediations where, the mediation has happened a month before a hearing. I had one case where parties had been effectively locked in trench warfare with each other for 5 years, had by that stage 2 adjudications, 3 arbitrations, and a high court case. And then 5 years in, they then eventually finally had a mediation, and the mediation worked. So it's very rarely too late for mediation, I have to say, but it can sometimes be too early, just if the parties aren't, particularly if a respondent isn't sufficiently bought into what the case is about, and therefore doesn't want to engage with it, because that to me is the essence. Both parties have to engage, they have to want to engage, they have to want to find a solution.
Mediator needs to make sure he closes the deal. I once had a mediation where extremely hard-fought dispute. Both parties went to mediation. After 2 days, the mediator thought he had a deal. He said, "I'm going to go to the hotel, check out so I can save you a night's hotel bill. You guys write up the term sheet and I'll come back and sign it." By the time he got back into the room, both parties were in the room with the door slammed shut, no deal. So the final lesson of mediation is make sure you actually get the deal signed before you walk out the door. Well, thank you both very, very much. Really great insights and thoughts. As I said at the outset, we really invite the audience, if you have questions, to reach out to Matthew or Danya or me. We'd be delighted to talk with you about whatever further thoughts or questions or ideas you have, because you all probably have lots of experiences that would be useful for us to know as well. So thank you very much.
Thank you very much. Thank you very much. Thank you, Jason and the team. Thank you.
Thanks very much to the first grand panel for the excellent analysis of expedition and of resolving urgent applications quickly and fairly. As I mentioned at the outset, the funding of the resolution of disputes, and particularly costs of international arbitration, continue to be a significant factor for parties attempting to resolve disputes. Here to address us on this topic is Patrick Guerin. Patrick will explore the various options available to parties to mitigate cash flow strain during a dispute and to share risk with their lawyers and third parties. Patrick is head of Charles Russell Speechley's, or CRS, Middle East practice. Now he conducts from offices in Bahrain, Dubai, and Qatar. He specializes in all areas of dispute resolution. Patrick has conducted litigation and arbitration in a great many jurisdictions, including all the GCC states and all the courts within the English jurisdiction. Patrick leads the CRS Middle East Disputes team, which won the Bahrain Dispute Resolution Law Firm of the Year Award at the Chambers Middle East Awards 2019. And he also leads the CRS International Arbitration Group, which won the International Arbitration Team of the Year at Legal Business Awards in 2018. Patrick is admitted to practice in England and Wales and was awarded a Chartered Institute of Arbitrators, or CIARB, diploma in international arbitration in July of 2018 and became a CIARB Fellow in September 2018. Over to you, Patrick.
Thank you, Victor, for that kind introduction, and welcome everybody to a fairly short canter through the options that are available currently for arbitration funding. So why are we talking about arbitration funding at this particular moment in time? For those of you that are lovers of medieval law, you will know well the phrases champity and maintenance. In basic terms, dating back to the Middle Ages, these laws prevented people from providing financial assistance to litigants or parties to a dispute. Main rationale behind that was to prevent wealthy lords and landowners from interfering in cases that they had no business interfering with. And that effectively, those laws have effectively prevented financial support from non-parties for many centuries. Indeed, it's only been in the last 10 years that in common law jurisdictions to which maintenance and champity mainly applied, these laws have effectively been overturned, allowing things like third-party funding to gain momentum. And there's been a shift in the conversation, really, away from principles like champity and maintenance, more to access to justice type principles that have encouraged funding models, funding options to give people greater access to justice. So that's one of the big issues, particularly in the common law space, that's developed over the last 10 years. Not such a problem in civil law jurisdictions. Champity and maintenance weren't really live issues there, but certainly anything in the common law space was heavily influenced and has heavily changed as a result. We're living in times where cash flow constrictions are very much part of everyday business life. People are experiencing delayed payments, non-payments, projects are being delayed, contracts and contractual relationships are being renegotiated and varied, and there's an increase in the suspension and termination of projects. And this seems to be hitting both the public sector and the private sector alike. The focus on arbitration funding. Firstly, arbitration growing in popularity as a dispute resolution process. There are probably an increasing number of claims and disputes arising in the market at the moment, although current market conditions make it difficult for many companies, many businesses to take legal action, mainly because of cash flow constraints, mainly because of uncertainty, and mainly because despite the best efforts of arbitral institutions and arbitrators, arbitration is still a time-consuming and expensive process. It is increasingly adhered to, but one thing for the non-lawyers watching this is that it is important that you discuss with your lawyer at the outset of any dispute what the options are in terms of funding and insurance and all those things that should be foremost in your mind at the commencement of a dispute. It's actually a requirement in most jurisdictions, it's a regulatory requirement upon lawyers that they have to discuss different funding and insurance options to clients. They can only and should only enter into fee agreements with clients that are suitable for those clients' needs and very much take account of the client's best interests. The examples I've given there are from the Solicitors Regulatory Authority, which governs English lawyers, but those types of provisions are mirrored both in the DIFC Court Code of Conduct, Articles 17 and 18, and also in the QFCA rules and Part 6. So, in terms of the funding options, there are two real categories of funding options available. The first two relate to arrangements that can be entered into between clients and lawyers, and the second category are those that can be entered into between a client and a third party other than the lawyer. And they are conditional fee agreements, damages-based agreements, those two being the two that you can enter into with your lawyers, and then after the event insurance and third-party funding, which are the arrangements you can enter into with third parties other than your own solicitors. So starting with conditional fee agreements, everyone knows the expression no win, no fee. Pure no win, no fee conditional fee agreements are where you only pay your lawyer if you win, whether through an award or through a settlement. Obviously, defining what is a win is very important at the outset. In return, if you win, your lawyer will charge his normal fees plus an uplift, which will be agreed with you in advance. Increasingly common, because no win, no fee is sort of heavy on the risk side, particularly for the lawyers, increasingly common is a no win, low fee, which is a sort of partial conditional fee agreement, where you pay your lawyer as the case goes along at a much reduced rate, and at the end, if you win, again, definition of a win, very important. The lawyer gets paid the rest of his fees, what he would normally charge, plus an uplift on top of that. In either of these options, you as the party to the arbitration are still, depending on the arbitration rules that you are operating under, at risk potentially of an adverse costs order if you lose. And therefore it's always a good idea to consider after the event insurance to cover the downside risk to you should you lose your arbitration and an award be made against you in terms of the legal costs of your opponent, because that insurance then will kick in and pay those. More on that a bit later. With conditional fee agreements, unless the case settles early, you may well have to think about instructing counsel or an advocate to represent you at any final hearings. Counsel may agree to do the case on a conditional fee arrangement on the same basis as your lawyers, but depending on the terms agreed with your counsel, you may well be responsible for payment of their fees on a non-CFA basis. And the same goes for court fees, expert fees, and translation fees. So what do law firms look at when they're considering whether to do a case on a conditional fee agreement? Firstly, it's merits. And there are two types of merits that law firms focus on. There are the legal merits. Is your case legally meritorious? And then there is, completely separate to the legal merits, what is the likelihood of a recovery being made against the opponent in the event that the case is won? As I said earlier, the law firm is obliged to assess a client's financial position and assess that position throughout the whole of the likely length of the proceedings. It also shows commitment to the client that the law firm believes in the client's case and is prepared to share risk with the client. Claim value has got to be, is important, has got to be assessed right at the outset. That will have an influence both in terms of the realistic time frame of the case, but also on the appropriate level of risk sharing between the law firm and the client. Oftentimes, conditional fee agreements are entered into because the case itself does not quite satisfy the criteria for a damages-based agreement, which I get onto now. So this is a slightly different model in that the lawyer takes fees out of the equation completely in return for a share of the damages that are awarded to the client at the end of the case. So with a damages-based agreement, very similar to a pure conditional fee agreement, you don't have to pay the lawyers as you go along at all. Instead, you will agree at the outset of the case what percentage of the damages the lawyer will receive, and the lawyer will take that percentage at the end of the case on the basis that there's been a win. Most jurisdictions, that percentage figure that the lawyer is entitled to can't exceed 50%. Obviously, if under a damages-based agreement, if you don't win your case, then you don't have to pay your lawyer anything. And again, it's the same issue with disbursements, and particularly advocates' fees. Unless you can get your advocate to do the case on a damages-based agreement as well, you may well have to budget to pick up his or her fees as you go along. Again, you'll remain liable for your opponent's costs, and again, you should think of after the event insurance to mitigate that particular risk. Payments under DBAs can be staggered or staged, and obviously there's a greater level of risk on the law firm in terms of non-payment of the risk of non-payment of fees. So with damages-based agreements, what are the assessment criteria that law firms apply? Usually it's where either a client just refuses to pay or just does not want to pay for the legal fees of a case as they go along, or simply can't pay. Again, it's a situation where the law firm is prepared to share the risk of the outcome of the case with the client. It's fair to say, I think, with damages-based agreements that the risk profile is higher for the law firm, and therefore the propensity of law firms is to do cases that are relatively straightforward, lacking in complexity, both legal and factual. They prefer, because they're easier to predict. And you'll often see that lawyers will calculate the level of percentage that they would want to do a case in a damages-based agreement to at least cover what they anticipate will be the work in progress costs to their law firm as they go along with the case. I've touched on after the event insurance. It's a safety net, covers the risk of having to pay your opponent's costs, again, depending on which arbitral forum you're in the event that you're unsuccessful in your claim. It is also possible with certain insurance products to obtain your own costs after the event insurance, which will pay out on your own legal costs in the event that you are unsuccessful. Insurers charge a premium, obviously. It's typically a one-off, but that can be staged, deferred, or contingent on the outcome, i.e. payable only at the conclusion of the arbitration in the event that your claim is successful. It's often the case that if you are looking at either doing a conditional fee agreement or a damages-based agreement with a law firm or third-party funding with a third-party funder, they will insist that you obtain after the event insurance to cover your downside risk. Third-party funding, obviously grown considerably in the common law space since Champty and maintenance have been done away with. A third-party funder will fund your claim in return for a share of the proceeds, very similar to damages-based agreements that we've already discussed with lawyers. And it'll either be a share of the proceeds or it'll be a return on the capital that the third-party funder has invested. It's usual for the return on the funder's investment to be a multiple of the amount advanced in terms of the cash that's actually been advanced to cover the cost of the case, or a percentage of proceeds. Sometimes, relatively rarely, but sometimes there can be a combination model involving both a multiple of the amount that the funder has actually provided and also a percentage of the damages, and that often depends on the size of the case. Again, very likely that any funding agreement will insist that the client obtains after the event's insurance to insure against downside risk. So what will funders look at? Again, very similar to law firms with damages-based agreements. They will look very, very carefully at the legal merits and extremely carefully at the prospect of recovery in the event that you are successful. There is a level of risk sharing between the client and the funder, as you would expect, and that is a matter of negotiation at the outset. Oftentimes, the funder will want legal budgets set and capped, so that it has legal certainty that the costs aren't going to run away with themselves during the period that they're funding the case. Multiple claims facility I will get onto a little bit later. Advantages include taking the cost of funding off a business's balance sheet while fighting a case, and risk sharing, but also sharing in the reward. It's also a contributor to working capital management, and obviously relieves cash flow requirements of the business as the case is going along, because you won't have to pay the professional fees for the management of the dispute. It can also be an advantage in the sense that it conveys to your opponent the strength of your case. It conveys to the opponent that somebody independent has looked at the case and is prepared to fund it, and that can be very, very powerful, particularly in terms of negotiations. There are disadvantages. The share, which will be a significant portion of your damages, will be shared with the funder. There are increasing reporting obligations, both for the lawyers and for the client, in reporting to the funder throughout the life of an arbitration. And also you have to be very careful to set the parameters at the outside of the case in terms of creating conflict of interest between the funder, who wants a return on their investment at a certain level, and the client, who may want a higher level in terms of settlement in any negotiating situation. So where is this happening? As I mentioned in the context of Champty and maintenance, most common law jurisdictions are now involve third-party funding and CFAs and DBAs with lawyers. Increasingly, it's being used in civil code jurisdictions as well. Recent developments in Hong Kong and Singapore, both the arbitration centres there have embraced the idea of third-party funding, and there are now specific practice directions covering third-party funding and funding arrangements generally in the ADGM and DIFC court practice directions. Commercial arbitration and litigation and international arbitration increasingly are using funding models. as is insolvency practitioners, and it's increasingly being used in fraud and asset tracing cases. So I mentioned multiple sort of facility type funding arrangements, and this is relatively new, but is increasing. It started as an innovation in the UK market and is getting traction elsewhere. And it's a move away from a focus on funders looking at single cases and funding those single cases, mainly because there's been quite heavy criticism of that previous model, where there's very high pricing for the provision of the funding, very inflexible, a very low risk appetite adopted by funders, only willing to really fund very straightforward cases. So the funding sector has now shifting towards a more portfolio approach, where businesses who have multiple claims can use their claim portfolio, if you like, as a corporate finance tool. And funders will provide funding for a portfolio of claims where they can defray their risk to a greater extent than with a single case, and therefore do better in terms of pricing. So recent developments, increasing use of third-party funding in Islamic transaction disputes. There's no express allowance for third-party funding in Sharia law, but it's arguable that the principles of Sharia law don't prohibit third-party funding. In fact, some features of Islamic finance may be said to be analogous to third-party funding. The main areas of Sharia that are addressed in this context are riba, the charging of interest, garar, the excessive speculation, and mazir, which is gambling. But in general, no interest is awarded to a funder in a successful case, so there shouldn't be any riba issues. And as any of you that have gone through a funding process will know, the level of due diligence that is undertaken means that falling foul of the excessive speculation and gambling prohibitions under Sharia is very unlikely. So in the Qatar context, there's no history because it's a common law, civil law jurisdiction, no problem with the common law doctrines of shabti and maintenance. The 2017 arbitration law, which came into effect in April 2017, previously replaced the civil code provisions in relation to arbitration, which were about 27 years old at that point. So Qatar's become a far more effective place to undertake arbitration. And of course, there's been the rise of the QFC and the QFC rules that apply to arbitrations where Qatar is the seat, the QFC is the seat. Neither the Qatar arbitration law nor the QFC arbitration regulations contain any provisions regarding third-party funding of arbitration, and there therefore appears to be no reason to assume that third-party funding is not possible. So that's a canter through the current state of play in relation to funding of arbitration disputes. If any of you have any questions, please put them in the chat box and we'll deal with them as soon as they pop up. But for now, I'll hand back to Victor.
Thanks, Patrick, so much for those thought-provoking ideas on the funding of disputes. Certainly a lot of useful information for us to use going forward. We appreciate your time. Next, it is always a pleasure to introduce Dr. Zain Sharar of the QICDRC. Dr. Zain is a man of many talents. He serves as senior legal counsel of the CEO office of QICDRC and as an excellent and sought-after arbitrator. He has previously served as Director of Legal Affairs and Enforcement at Qatar Financial Markets Authority and was Assistant Professor of Commercial Law at Qatar University. He advises on new legislation, policy matters, and on legal affairs. Dr. Zain will address us on Qatar's arbitration regime and the specific role of QICDRC. Please, Dr. Zain.
Thank you very much, Victor, for the kind introduction, and I'm very delighted to participate in the 6th Annual International Arbitration Virtual Summit, which is organized by the Legal Plus. Today, I'm going to be talking about Qatar's arbitration regime and the role of the Qatar International Court and Dispute Resolution Center. The topic is very important, particularly for foreign investors and international companies who are contracting to do business in the state of Qatar and who favor arbitration over litigation in respect of resolving their disputes. So hopefully my presentation will assist them to choose the arbitration regime that responds to their business need, and also will help and assist them to draft the appropriate arbitration clause in their future contracts. So currently there are two arbitration regimes in the state of Qatar. The first one applies in the state of Qatar, and I will refer to it as the state arbitration law. And the second one applies at the Qatar Financial Center, which is also known as the Qatar Financial Center Arbitration Regulation, or the QFC Arbitration Regulation of 2005. The state arbitration law is the primary arbitration law in the state, which applies to both domestic and international arbitration seated in the state of Qatar. Also, it applies to ad hoc and international arbitration. The law was issued on the 16th of February 2017, and it was published in the official gazette on the 16th of March 2017, and was entered into force on the 16th of April 2017. It should be noted here that some people are still referring to the state arbitration law as the new arbitration law, even though the law has been issued more than 3 years now. The state arbitration law has replaced the arbitration regime or the arbitration rules, which were part of the Civil and Commercial Procedural Law number 13 of 1990. And it's also important to mention that the law is based and modeled on the Institutional Model Law on International Commercial Arbitration. However, there are key differences between the state arbitration law and the Institutional Model Law on International Commercial Arbitration. Particularly, the state arbitration law requires the approval of the Prime Minister in respect to arbitration clause that is part of administrative contracts. Civil law lawyers will be familiar with the concept of administrative contracts. There is no legal definition of administrative contracts in Qatar's legislations. However, the Court of Cassation in the state of Qatar has considered a contract to be characterized as an administrative contract if it meets the following criteria. Firstly, one of the parties must be a public entity. Secondly, the subject matter of the contract must be to provide or manage a public service. And thirdly, the contract must contain unusual or onerous terms for the benefit of the public entity. So if all these criteria are met, then the contract is considered to be administrative contract. And in these contracts, the approval of the Prime Minister is very important in terms of including an arbitration clause. Also, the state arbitration law differs from the Institutional Model Law that it prohibits public sector entities from resolving any dispute that may arise among them by arbitration. Also, the state arbitration law requires the arbitral tribunal to include a copy of the arbitration agreement in the body of the arbitral award. Also, the state arbitration law allow the parties to request for the correction of the arbitral award within 7 days of the receipt of the award, as opposite to the 1 month period provided by the Institutional Model Law. And also the state arbitration law set the statutory time limits for a party to file for a request to annul an arbitration award within 1 month, as opposite to the 3 month period provided by the Institutional Model Law. Again, as I stated earlier, arbitration can be conducted under the Qatar Financial Center Arbitration Regulation if the QFC is chosen as the seat of arbitration. And as you all probably know, the Qatar Financial Center has a separate and independent legislative and judicial system from the state of Qatar. And according to Article 2 of the QFC arbitration regulations, the state arbitration law does not apply in the QFC. So the question that may arise now, which legislation is better? Is it the state arbitration law or is it the QFC arbitration regulations? And before I answer this question, it's very important to mention that there are 4 well-known fundamental principles which shape modern arbitration laws. These principles are party autonomy, the separability of the arbitration clause, competence, competence, and the limitation of court assistance and supervision. Basically, the International Model Law has adopted all of those 4 principles, and also both the state arbitration law and the QFC arbitration regulation has adopted those principles. So both legislation, for example, allow the parties to choose the procedures to be followed by the arbitral tribunal, and also both legislations consider the arbitration clause as an independent and separate agreement from the main contract that contain it. So if the main contract is considered to be null and void, or the main contract has been terminated, this shall not entail the invalidity of the arbitration clause. And also the both legislation both legislation give the power to the arbitral tribunal to decide on the jurisdiction, and both legislation also limits the court intervention during the arbitral proceedings. Also, it's very important to mention that there are quite a number of similarities excuse me, between the state arbitration law and the QFC arbitration regulations. So basically, both laws allow the parties to choose the substantive law, to choose the venue, to choose the number of arbitrators, and both legislations basically have similar requirements in terms of the arbitration agreements, and both legislation has adopted the wider scope definition of the in-writing meaning for the arbitration agreement, and both legislations have a similar requirement for the arbitral award. However, there are some differences between the state arbitration law and the QFC arbitration regulations in terms of the following. The state arbitration law requires the arbitral tribunal to send an electronic copy of the arbitral award to the concerned department at the Ministry of Justice. And also the state arbitration law requires the approval of the Prime Minister to arbitration clause in administrative contracts, as I mentioned before. And also the state arbitration law have different statutory time limits in some provisions. So the question is now, which one to choose as a company? Is it the state arbitration law or the QFC arbitration regulations? First of all, it depends whether the company is a QFC registered entity or not. If the company is a registered QFC company, then it cannot choose the QFC as the seat of arbitration and can arbitrate under the QFC arbitration regulations. However, if the company is a non-registered QFC, there's been a debate among legal practitioners here in the state of Qatar whether a non-registered company can choose the QFC as the seat of arbitration and can subsequently arbitrate under the QFC arbitration regulation. even although actually the QFC arbitration regulation on its face allow the parties, if they are non-QFC companies, to choose the QFC as the seat of arbitration and arbitrate under the QFC arbitration regulation. Currently, there aren't any cases at the Qatar International Court to confirm whether a non-QFC companies can arbitrate under the QFC arbitration regulations and to choose the QFC as the seat of arbitration. However, and having said that, if you are choosing or if you want to choose the QFC as the seat of arbitration only to utilize the Qatar International Court services, being a court model on the best leading international commercial court, and you would like to work under similar procedures to those in the common law system, you still can utilize the court services if you choose the Qatar International Court as the competent court in the arbitration clause. So according to the state arbitration law, the competent court can be the civil and commercial arbitration dispute circuit at the Court of Appeal, or it could be the first instance circuit at the Qatar International Court, only if it's chosen by the parties as the competent court. So if you make sure to choose the Qatar International Court as the competent court, then you can utilize the court services, and then the court can discharge its supportive and supervisory role during arbitral proceedings. Now I'm going to move to the second part of my presentation, and I would like to talk about the jurisdiction of the Qatar International Court and the role it's play under the state arbitration law and the Qatar Financial Center arbitration regulations. The Qatar International Court, also known as the Civil and Commercial Court of the Qatar Financial Center, was established by the Qatar Financial Center Law number 7 of 2005. According to the Qatar Financial Center Law, the court have limited jurisdiction over specific subject matters. So basically, the court, according to the law, has the power to hear all matters and disputes that arise from contracts, transaction, arrangement, or incidents that take place in or from the QFC. Also, the court has the power to hear and decide all matters and disputes which arise between QFC authorities and QFC registered entities. Also, the court has the jurisdiction to hear and decide all disputes and matters which arise between QFC registered entities and their contractors or their employees, unless, of course, the party agree otherwise. And finally, the court has the jurisdiction to hear and decide all matters and disputes which may arise between a QFC registered entities and any other entities registered in the state out of the QFC. Moreover, the state arbitration law has conferred the court with additional power to discharge a certain supportive and supervisory role only when it is chosen by the party as the competent court. So so basically, the court function under the QFC arbitration regulation and under the state arbitration law are pretty much the same in respect of the appointment of the arbitrators or the removal of the arbitrators, or in terms of assisting the arbitral tribunal taking evidence, or in terms of setting aside arbitral awards. So my final remark for international companies and foreign investors, that there should be a great degree of care when choosing the arbitration regime in the state of Qatar, that best respond to your business need. And also there should be a great degree of care when drafting an arbitration clause. Please make sure, if you would like to utilize the Qatar International Court services under the state arbitration law, to make sure to mention the Qatar International Court as the competent court. Otherwise, the civil and commercial court at the Court of Appeal, sorry, the civil and commercial arbitration dispute circuit at the Court of Appeal will have the jurisdiction to supervise the arbitral proceedings. So again, make sure to mention the court in the arbitration clause as the competent court. Thank you very much, and I hope to see you in the future in another event. Thank you.
Thank you, Dr. Zain, for the very useful update and for assisting us in our understanding of the evolving role of the QICDRC. Also ever evolving is the role of the expert in dispute resolution. Here to help us with how we can get the most benefit from the use of our expert in a construction or engineering dispute is Phil Duggan with the ALIS. Phil is particularly qualified to help us out today, as he is a quantity surveyor with over 30 years of experience in the construction and engineering industries. He particularly deals with the preparation and valuation of variations, claims for prolongation, disruption, and acceleration, disputed accounts, and counterclaims and damages. Phil gained 12 years working experience with two of UK's largest multidisciplinary construction and engineering contractors, carrying out a full range of quantity surveying and commercial management functions on power station projects, water and sewage treatment works, petrochemical and process plants, as well as major civil engineering projects across the UK. For the past 16 years, Phil has been a consultant involved in claims, dispute, and expert work on major projects in about 20 countries, including all of the Gulf. Phil has experience across all sectors of the construction industry. He has been instructed on behalf of employers, engineers, main contractors, subcontractors, and JV partners in disputes. Phil has been involved in dispute resolution procedures, including litigation, arbitration, adjudication, expert determination, mediation, and DABs in various jurisdictions. Phil, over to you.
Thank you very much, Victor, for that very kind introduction. Hello, everybody. My name is Phil Duggan. I'm the regional head of the ALIS for the Middle East. I'm a quantum and delay expert, a quantity surveyor by background with over 30 years of engineering construction projects experience. I've been involved in many international arbitrations and also have litigation experience. I haven't been instructed on projects up to a value of 10 billion US, although I do find that even the smaller value disputes take up the same amount of time and input from an expert. Currently, I've been instructed as an expert on over 30 occasions, with approximately half of those needing oral testimony. So today, I'm here to talk about the role and duties of expert witnesses. And in order to do that, I'm going to talk through the expert appointment and duty, the approach that I take to expert work, report writing, preparation for a hearing, giving oral testimony, and then I'll summarise that, giving my opinion on what makes a good expert. To make the subject more topical, towards the end, I'll also cover some things about how a delay expert may assist in a COVID-related claim, and also how a quantum expert may also assist in a COVID-related claim. So in terms of the appointment and duty of an expert is normally instructed by a solicitor or attorney. This is usually because the solicitor or attorney will know the areas of the dispute that require expert evidence to be given. From my perspective, I think it's good practice to receive instructions in writing, which sets out exactly what I'm to provide my opinion upon. Those instructions often will identify any rules which the expert must be aware of, i.e. the relevant arbitration rules, and or anything that's relevant to the jurisdiction or other rules applicable to the dispute at hand. I think it's good practice for the expert to set out the instructions within their report. I say this because that allows the tribunal or the court to understand exactly what the expert has been asked to provide his opinion or her opinion upon. It should be noted that the expert's duty is to the court or tribunal and not the party that pays the fees. In other words, there's an overriding objective for the expert to be independent. An expert should always make sure their opinions are only based upon areas that they have expertise in. And to highlight the importance of the role of an expert, they will always sign a declaration of truth in any report and will also swear on oath before giving oral testimony. I always advise clients to consider the early appointment of an expert, as I believe it can greatly assist to put together a claim or defence that the expert would generally support, certainly in principle. It is, however, a fine line between making sure an expert is not compromised in terms of independence when getting them involved at an early stage. And I always advise that the lawyer should be involved when the expert is appointed. It's important to remember that the expert should not advocate the claims of the claimant nor rebut them for the respondent. Instead, they should give their opinion on the relevant aspects of the claims based upon their expertise and the evidence that's provided. For example, a quantum expert will provide an opinion upon the principles of evaluation and the values applicable to a claim made, irrespective of the legal arguments about the entitlement surrounding that claim. Often clients want the expert to do exactly the above and to advocate their claim or rebut the claim, but it's really not in their best interest for the expert to do that. Expert work is very much an analytical process, which is based upon the facts and the evidence provided, and the case as pleaded by the parties. In terms of my approach to expert, especially in terms of quantum roles, I make sure all my checking and auditing is thorough and follows best practice. It's important that I don't develop a claim that is not pleaded. Where required, an expert should engage with an opposing expert in order to narrow issues and should never seek to hold a position where it's clearly not reasonable. Again, this would be exposed during cross-examination. In terms of report writing, reports should always be clear and concise and should be written in the first person. After all, it's an individual's report and not that of a particular company. The report should be restricted to provide an opinion on the matters instructed to do so, and insofar as the expert has the skills and experience to give such an opinion. One of my big frustrations when reading and opposing expert reports is that often graphics are included, which are illegible, and I always advise experts not to include graphics that are illegible. Often experts will use assistants in their work, and it's important that the expert identifies which assistants they've used and the specific tasks that they have been undertaken. The expert will normally identify that they have checked the work done by their assistants and will always adopt that work as their own. When writing a report, the expert should always remember that they are likely to be cross-examined on any aspect of it. In order to aid the tribunal, it's good advice to make sure all source documents, exhibits, and references to the pleaded case are properly cross-referenced. I believe you should always maintain courtesy to fellow professionals when referring to an opposing expert's report. I always advocate leaving the aggressive language to the lawyers. After all, they're far better at it. Finally, you should ensure that the report is signed and complete with all necessary supporting appendices and exhibits. So, preparing for a hearing. It should be noted that hearings usually take place a considerable time after the reports have been written. And it's imperative for the expert to undertake an in-depth review of all the analysis undertaken previously and the opinions that were stated. In completing this review, if any errors are discovered, the expert should not simply hope that they don't get spotted. They should immediately address them with instructing solicitors or counsel, and possibly even the opposing expert. Normally, they'll bring any errors or omissions to the tribunal's attention, and sometimes the expert is given the opportunity to do this at the start of their testimony. An expert will usually assist instructing solicitors and counsel for preparing cross-examination of opposing experts. This usually entails identifying questions and areas of cross-examination where it is believed it best suits the client's case. This is always done though on the knowledge that the opposing expert is also doing the same. So the hearing itself, an expert should remember that they are not on trial. Their professional opinion has been sought to assist the court or tribunal to make decisions in areas of specialism that the court or tribunal members don't usually have. It's seldom a memory test. Questions are usually based upon what the evidence is within the report and what the expert has said within the report. And usually they'll be taken through the relevant documents as counsel asks questions. Questions should be answered calmly and honestly, using time to think properly where necessary. An expert should never argue with counsel who are cross-examining. Questions are normally delivered to the expert by the opposing party's counsel, whether that be a QC or advocate solicitor. So the expert receives the question, but then delivers that answer to the judge or tribunal. I always say that for a bad or ill-prepared expert, cross-examination is never a pleasant experience. So in my view, what makes a good expert? Gravitas, seniority, strength of CV, real experience in the subject matter at hand, intellect, relevant qualifications, practical and recent relevance experience. Often when I talk to lawyers, they make comments about boutique expert companies in the market these days, and such experts who have lost touch with the reality of construction projects, i.e. they're no longer involved in live projects. It's important that the expert works within the team, whether that be the legal team, the clients, or even with other experts. It should also be remembered that an expert whose evidence fails is a waste of fees, and more importantly, can seriously damage your case. So some topical considerations for our current climate. Here I'm going to cover some considerations for COVID-related claims in regards of delay matters. In my experience, it's likely that different causes of delay and or disruption lead to different entitlements arising under the contract. For example, a force majeure event may mean the contractor is not entitled to recover any costs, whereas a change in legislation may allow recovery of costs. In particular, there's been recent legislation introduced in Singapore and Malaysia that is allowing contractors to recover costs associated with COVID-related matters. Based upon my experience, I expect a party's delay events to include, although not be limited to, things like labour shortages, caused, for example, by reduced busing capacities, social distancing on the buses and the like. Also, social distancing requirements at work fronts mean that labourers can't get too close to one another. This may mean a reduction in the labour headcount. We're aware of many areas of material shortages, particularly in the early days of the pandemics, when a lot of countries closed their borders. We've also noted that engineering, management and supervision absences have occurred, in particular early on in the pandemic, when a lot of people were stuck in the Far East as travel bans kicked in. Because of the intrinsic nature of the different delay matters, I expect a party's delay analysis methodology will need to identify specific events arising from COVID-19 and their individual impact on the critical path. I believe that delay analysis will probably be more intrinsic than is typical. This is because there will no doubt be competing and concurrent effects arising from other different causes. It will be essential, however, to assist the party in claiming delays and cost recovery to make sure that the events are stripped down and identified as closely as possible. For example, I would expect a party to identify clear stoppages of work easily. However, as has been the case across the Middle East, most construction projects have continued. In this regard, the delay analysis I expect to be a lot more complicated. In terms of the quantum side of COVID-related claims, the quantum expert will need to work very closely with the delay expert and instructing counsel. It's important that they understand the basis of what's compensable and the basis of any evaluation. For example, some matters may only allow time recovery and no cost. Some matters may allow cost recovery, while others may allow cost plus a reasonable profit. It's important that the quantum expert considers the definition of cost. For example, in a standard FIDIC, this includes addition of overhead. It's also important to understand which circumstances allow recovery costs, and that should be also a reference to the contract. For the quantum expert, there will be an emphasis on reviewing the records to enable a robust assessment of a party's pleaded case. It should also be noted that not all quantum will flow from the delays. There are other aspects to consider, and I would expect to see a party's pleaded case arising from COVID-19 related claims to include such matters as premium time working. This is particularly the case where split shift working has had to be introduced due to labour shortages allowed on site. Additional supervision will be required to go with those extended shift patterns. I've seen instances of extra transportation costs. As I mentioned earlier, with reduced capacities on buses, that normally means extra buses are required. Also, there'll be additional health and safety input, revised method statements, for example, updated site movement plans. Additional PPE and COVID testing has arisen on most sites across the Middle East. I've seen a number of situations where supplementary agreements have been developed and negotiations on projects have already happened during the outbreak. The downside of this is often those supplementary agreements have been predicated upon an expected end of the pandemic, which has gone on far longer than most people expected. The pandemic has no doubt also caused price escalation and currency fluctuations over the world. And certainly across the Middle East, there's been a large increase in the amount of suspensions of work and terminations as parties have got nervous about spending more money on their construction projects. So that's the end of what I wanted to discuss today. I'll be happy to gather any questions from you. Thank you very much for listening to me.
Thanks very much, Phil, for those timely and practical tips on the use of experts. As an arbitrator, I appreciate the work of experts and commend these tips to counsel to use to make their work even more efficient and effective for us. Next, we have some very useful insights from a renowned expert in post-M&A valuation. Most interestingly, she will be discussing post-M&A disputes, highlighting a number of areas where COVID-19 would affect these valuation disputes. Ms. Rula Harfouch is a partner in forensic accounting and commercial damages with HKA in London. She specializes in the assessment of damages in complex valuation issues in litigation and international arbitration contexts. She has experience in matters involving breaches of contract, investment treaty claims, transaction-related disputes, and intellectual property infringements. Ms. Rula is recognized as a legal expert by Who's Who Legal in the Thought Legal's Global Elite List in arbitration and for the quantum of damages. She has testified in both English and French and has worked on many matters involving parties from the Middle East and North Africa, as she also speaks Arabic. Ms. Rula, if you please.
Thank you very much for the kind introduction, Victor. I think it's fair to say that COVID-19 has increased the volatility of asset prices and uncertainty about the future. As a result, disagreements about value, which is based on expectations about the future, have increased because of COVID-19. In particular, disagreements about the future and therefore divergent views on value between buyers and sellers of companies have been exacerbated. These disagreements have led and are expected to continue to lead to post-M&A disputes. In this presentation, I'm going to talk about post-M&A disputes with a focus on valuation and highlight a number of areas where COVID-19 would affect these valuation disputes. This will be relatively high level because of time, but if there are any questions, please send them through and I will try to answer them at the end of this talk. So, post-M&A disputes are caused by disagreements between buyer and seller. I will focus in this presentation on buyers and sellers of companies. M&A disputes can be categorized as pre-closing or post-closing disputes. Pre-closing disputes, there's a failure to complete. We're generally talking about the buyer seeking to pull out of the deal, but it could also be the seller. And this could be caused by force majeure or material adverse change clauses being triggered, failure of the buyer to obtain funding, regulatory issues, and failure of the seller to meet pre-closing conditions, for example, breaching operating covenants. Post-closing disputes can be caused by breaches of representations or warranties. As a reminder, the seller's representations in an SPA are generally statements about past or existing facts about the target company. Their purpose being to guarantee the accuracy of the information provided by the seller about the target company's financial and operational status as at the date of closing. The seller's warranties, on the other hand, are generally forward-looking promises about the performance of the target company, their purpose being to guarantee a certain level of future performance. Second causes of post-closing disputes are fraud or failure to disclose. Such claims are generally based on the seller intentionally concealing critical information from the buyer during pre-contractual negotiations, which, if disclosed, would have had a significant impact on the buyer's valuation of the target company. The claim for fraud offers a route to disapply any limitation or cap on the seller's liability for breaches of warranty. Also, it can offer the buyer a way to exit the transaction by rescinding the SPA and being restored to its original position. Third cause is completion adjustments disputes. These are adjustments to the purchase price between the SPA date and the completion date. For example, a transaction may be predicated on a set of accounts at, say, 31st of December, but the closing date is, say, 31st of March. Therefore, a mechanism for adjusting the accounts between those two dates may be necessary. Sometimes this leads to a dispute on how to adjust the accounts, especially when there are large or unexpected changes between the set of accounts. And finally, earn-out disputes. Earn-outs are where part of the purchase price is contingent on the future performance of the target company after the acquisition. Disputes arise about whether the thresholds of the metric or metrics on which the earn-outs depend have been reached and on the calculation of those metrics. Now, what makes post-M&A disputes more likely to happen? Mainly uncertainty and volatility, whether economic, market, or regulatory. An SPA is agreed at a set point in time, even when with mechanisms that allow for some flexibility, such as completion accounts. When the background is uncertain and there is added volatility in economic or market conditions, then it increases the chances of a transaction which was a mutually good bargain to end up being a bad deal for at least one of the parties. A buyer pulling out is harder to replace due to lower market demand in volatile conditions. Completion accounts are harder to compute because more estimates are required or the estimates are more difficult to agree between buyer and seller. And whether or not warranties are breached becomes harder to assess. The second factor is time. The longer it takes to complete the transaction, the more time there is for such things as force majeure or material adverse change clauses to be triggered, or for regulations to change. As such, COVID-19 has led and will continue to lead to more post-M&A disputes, not only because it has increased uncertainty and volatility, making estimates more difficult and controversial, but also because COVID-19 has led to restrictions on operating purchase businesses. Think, for example, of the transport and hospitality sectors. So previously agreed earn-out thresholds are now unrealistic, and COVID-19 makes it more difficult to market a business for sale after a deal has failed. The post-M&A valuation disputes I'm going to focus on in this presentation are valuation issues in case of failure to complete the transaction and diminution in value claims in post-closing disputes, in this case related to breaches of representations or warranties. So starting with valuation issues in case of failure to complete. The purchaser has failed to close the transaction and the contract has been terminated. What is the seller's loss? The general approach to calculating losses is to assess the difference between first the counterfactual position the seller would have been in had the transaction closed as envisaged by the SPA, that's often called the but-for scenario, and second, the position the seller is actually in, it's the actual situation. Now, the counterfactual scenario, unusually in disputes, is more straightforward than the actual situation because we have an SPA that sets out the purchase price. However, if the SPA includes a purchase price adjustment based on completion accounts rather than a locked box mechanism, there will be an adjustment for closing accounts. There may also be an earnout to assess, which will be based on estimates. So the but-for scenario may not be as simple as it first appears. Now, the actual situation, in the simplest cases, the seller finds another buyer, presumably at a lower price. So the loss would be the difference between the original SPA price and the new sale price. There may be questions about whether the new sale price is the best that the seller could have obtained. In particular, if the seller has a duty to mitigate its loss under the relevant law. There will also be questions about the date of loss assessment, in particular if the original SPA or the new sale contract contain completion adjustments or earnouts, in which case neither of the sale prices would be known for a while. While the date of breach can be considered to be either the date of termination of the SPA or the stated closing date, it's not correct to assume that this is the date at which the actual value of the business should always be assessed. More on that in a minute. The value in the actual situation could be more complicated still if the seller cannot find another buyer. So the value of the target company would need to be assessed assuming typically willing buyers and willing sellers, even if there are no willing buyers. Now that does not mean that the target company is not worth anything. The seller and the original buyer took some time to negotiate the SPA. So a period of marketing, due diligence, and negotiations would need to be assumed. In the meantime, the seller is still in possession of this business. So at a minimum, you would need to consider the value of the target company retained by the seller. This is akin to estimating a value in use for financial reporting purposes. The appropriate valuation method would likely be a discounted cash flow, or DCF, in which the future cash flows to be generated by the target company as part of the seller's business or as run by the seller are forecast, and then discounted to a present value to take into account the time value of money and the risks inherent in those forecasts. There will be debates between buyer and seller about the forecasts, as the seller will have an incentive to make them as conservative as possible, and the opposite for the buyer. Now, the past cash flows of the target company would be a good starting point. And also, remember, a lot of information would have been collected for the due diligence of the buyer, including potentially some presumably optimistic forecasts prepared by the seller. So this information will be useful to forecast the future cash flows of the target company in the actual situation. There will also be debates about the date of valuation, and in particular, about whether hindsight can be used in the actual situation. That is, whether information that only became available after the date of breach can be used in the valuation. Now, hindsight is often a contentious issue in valuation disputes, but that is typically in respect of the counterfactual scenario rather than the actual situation. Let's move to valuation issues in case of breach of warranties or representations. In this case, the transaction has completed, and the buyer claims that the seller has breached its representations or warranties. Let's also assume that the buyer does not claim the reversal of the transaction, but claims that the price it would have been prepared to pay but for the breaches would have been lower than the SPA price. Now, in practical terms, damages would be assessed as a diminution in value. That is the difference between the SPA price and the price that the buyer and seller would have agreed had the seller not breached the SPA. The question becomes, how does the breach impact value, which is assumed to be, but is not necessarily the same as asking, how would knowledge of the breach have affected the price that the buyer was willing to pay? Now, typically in an M&A transaction, the buyer and seller would value the target company using a number of valuation methods. As I said earlier, the value of a business is a function of the profits or cash flows that this business will generate in the future. So the valuation of the target company will entail preparing forecasts. The buyer and seller will then negotiate the price and terms of the SPA. They may discuss the target company's forecast in detail, and they may also review comparable companies and transactions in the sector. However, in the end, and more importantly in the SPA, the agreed price will be a negotiated figure, and it will likely not correspond to any of the valuation models or scenarios prepared by the buyer or seller. Also, for simplicity, the agreed price may be expressed as a multiple of a historical metric, say a multiple of the last 12 months EBITDA, say 8 times EBITDA, even if the price was not arrived at by multiplying the last 12 months EBITDA by 8. Now, in principle, this metric, EBITDA in this example, has to be representative of future maintainable earnings. So it must not include the impact of one-off or exceptional non-recurring items. Sometimes this is forgotten by the time the SPA is finalized. Let's have a look at an example. What is the impact on value of the breach if the breach is under provisioning for bad debt? Now, the buyer will say that the bad debt provision should have been £1 million higher. So the EBITDA should have been £1 million lower. This means that the purchase price I would have been prepared to pay would have been 8 times that, so £8 million lower. That is my loss. The seller will say that the bad debt provision was only understated for the last 12 months because of an exceptional issue with a particular customer. So going forward, the bad debt provision would return to its normal level, which was the level assumed in the SPA. In other words, the adjustment to be made to the SPA price is for £1 million, not 8. Now here, a mix of investigation and valuation skills will be needed to understand the most likely impact of the breach on the valuation and then on the purchase price that would have been agreed. COVID-19, of course, complicates these typical post-M&A disputes because, taking our example, it becomes harder to gauge whether a breach of warranty has a one-off or permanent impact. Is the impact of COVID-19 itself a one-off shock, long-lasting or permanent? It's a challenging question. More generally, the increased uncertainty and volatility mean that future cash flows will be harder to forecast. And the risks attached to these cash flows, that is the discount rate in a DCF valuation, will become more contentious. And if you're using multiples valuations, historical transactions may not be representative of the current market, and listed comparable company multiples may not fully reflect the impact of COVID-19 due to the lag in availability of results. Many other issues that will cause M&A valuation disputes are impacted by COVID-19, and I have not had the time to cover them in this presentation. They include fraud and failure to disclose. Now, these can be tied to issues we've already discussed, such as the impact of breaches of representations of warranties. And finally, earnouts. Now, they're often a contentious area due to poorly defined metrics, and these are made worse by COVID-19. For example, do those metrics include or exclude government support? Secondly, uncertainties over the timing of meeting targets. So should we allow or not time to recover from COVID-19 and or from the government restrictions? And thirdly, the scope of any restrictions on the target or the buyer's ability to take certain steps during the earnout period that could influence whether the earnout is realized and its quantum. Hopefully, this has given you all food for thought. Thank you very much for listening and take good care.
Thank you very much, Ms. Ruler, for demystifying what can be a very complex area indeed. This should allow us to navigate the post-closing purchase price adjustment landscape with more confidence. Thanks again. Next, we are pleased to have the second grand panel. This grand panel deals with the ever-important matter of the enforcement of that award that we have worked so hard and spent so much money to achieve. We are indeed fortunate to have three very polished and practiced expert lawyers to guide us through this crucial area. To introduce the second grand panel, we have David Kim, Senior Foreign Attorney with Lee & Co.'s International Dispute Resolution Practice. Notable for this region, David Kim is co-chair of the firm's International Construction Dispute Resolution Practice Group. He has acted in disputes administered by the usual alphabet soup of institutions, as well as in ad hoc arbitration under the UNCITRAL rules. He has represented multinational corporations, government entities, defense contractors, and high-profile individuals in numerous commercial disputes across many sectors. He has worked as litigator in Canada, has presented training at the Supreme Court of Korea, and has been a board member and a sessional lecturer at the Korean Commercial Arbitration Board, or KCAB. David, please introduce your second grand panel.
Thank you, Victor, for that very warm introduction. We're currently now on the last panel discussion for today, and it's involving the enforcement of awards and regional updates specific to Qatar, Japan, and Korea. Today, we have two very eminent speakers on this point. I'm very honored to introduce both of them. The first is Dr. Ihab Maher Al-Sanbati. He is Senior Legal Counsel, Senior Advisor to the General Counsel of the QIA, and is responsible for corporate and special projects and transactions. He served for 6 years as Senior Legal Advisor to the Office of the HRH, the Emir of the State of Qatar. He's previously served as the Egyptian Public Prosecution and Judiciary for more than 15 years, and his last position was as judge in Cairo's Court of Appeal. He is admitted to the bar and a certified and practicing arbitrator and mediator. Dr. El-Sanbati specializes in sovereign wealth funds, financial investment institutions, commercial transactions, governance and compliance, investigations, crisis management, white-collar crimes, and criminal justice, cyber laws, litigation, and private international law. My second speaker that I'm proud to introduce is Mr. Tony Andreaitis, who's been residing in Japan for over 10 years, but he is at heart a native of New York City, where he previously clerked for a federal judge in the United States Court of International Trade. Tony Andreaitis is a partner with DLA Piper in the Japan office. He leads a Tokyo-based International Arbitration Group, and he also serves as president of the Greek Chamber of Commerce in Japan, as well as a board member of the European Business Council. Further, Tony is also an adjunct professor at the Tokyo campus of Temple Law School and a part-time lecturer at both Keio Law School in Tokyo and Humboldt University in Berlin. So we're very grateful he's been able to find the time to come here and give us his thoughts today. As I mentioned earlier, today's topic is on the enforcement of awards, and many times as counsel, both in-house as well as in terms of firms, we're focused very much so on the arbitration proceedings themselves in order to get the desired effect of getting an arbitral award. But in many ways, especially for in-house counsel, they'll be quite interested to know what are the practical aspects of enforcing those awards in other jurisdictions. And as we know, in the Qatar and MENA region, there's many investments and many businesses, and therefore inevitably many disputes. And so we're very grateful to have both Dr. El-Sanbati and Tony here today. Dr. El-Sanbati, if I might just ask, could you perhaps give a general sort of status of enforcement in Qatar when it comes to enforcing arbitral awards?
Thank you, David. Let me first express my appreciation to the organizers, Legal Plus, to give me the opportunity to be with distinguished panel like yourself and Tony, and the very distinguished attendees of this event. Let me set the scene first by talking a little bit about the optimistic approach to arbitration in the region in general. We have seen that there is increased involvement in the countries of the region in the global trade and the investment, and efforts to reinforce the rule of law and establish a mechanism to respect contractual commitments in all the countries in the GCC. Let me be specific. I think Tony will be covering the Japan and the Korea and that area as well. We have seen enactment of modern arbitration laws throughout the region in Qatar, Oman, Jordan, Saudi Arabia, QFC, DIFC, and so on and so forth. And we have seen the establishment of very distinguished regional arbitration centers that are like growing in a very consistent manner, such as QIC, DIAC, DIFC, and so on and so forth. So what I want to say is that the future looks bright with all the efforts that are done in the region in terms of the governmental sector, the private sector, and the practitioners such as yourselves and Tony. I think the first thing that the audience would be interested to know is that Qatar is a member in New York Convention. It was joined and ratified, and according to the Qatari Constitution, it is considered a part of the national legislation of the state of Qatar without any reservations or objections. The second thing is that Qatar has a very modern law based on the Unilateral Model Law. It was issued in 2017, and I think it is of sufficient satisfaction to the practitioners, having seen that the local law is trying to be in a great compliance with international standards. Again, to set the scene or the context of the enforcement, two important definitions that we have to illustrate from the Qatari law. The first one is what is the competent court, and the second one, what is the competent judge. The competent court, according to the definition of the law, is the civil and commercial arbitral dispute circuit in the Court of Appeal in Qatar, or the first instance circuit of the Civil and Commercial Court of the Qatar Financial Center pursuant to the agreements of the parties. And the rationale behind that is to make sure that the competent court that will be responsible in relation to enforcement, because in general it is responsible of the entire legitimacy matters, procedural matters according to the law, as you can imagine. But it is if we focus only about enforcement, it will look at the to be the appeal level in relation to the decisions that are issued by the competent judge when it comes to enforcement. And it was chosen by the legislator to make sure that the court that is looking to the arbitration matters is of a high level, certain qualifications, certain expertise, to avoid any mistakes or unexpected interpretations or implementations of the provisions of the law, and again from the perspective of the state to prepare the road for more successful arbitrations, more successful enforcements, and so on. And the competent judge is defined to be the enforcement judge in the first instance circuit of the Qatari courts, or the enforcement judge in the Civil and Commercial Court of the Qatar Financial Center pursuant to the agreement of the parties. I know that my colleague Dr. Zain has covered the regime that is established within the QFC. So here we will be focusing on the enforcement according to the Qatari law and the Qatari court. And Article 34 of the Qatari law on arbitration is detailing the reasons that and the procedures for the enforcement and the reasons why a side or the court in itself can refuse to recognize or to reinforce an arbitral award. And firstly, the law sets the principle that any arbitral award will have the status of res judicata and shall be enforced in accordance with the provisions of the law, regardless to the country in which the award was issued. So that is an important principle. And the procedures to enforce is to make an application to the competent judge. We have already spoken about the definition of the competent judge, with a copy of the arbitration agreement, the original award, or a certified copy of it in the language in which it was issued, along with the certified Arabic translation if it was issued in a foreign language, unless the parties agree on alternative methods to enforce the arbitral award. The application for the enforcement of the arbitral award shall not be accepted until the lapse of the time limit set for the submittal of the application for setting aside the arbitral award. Then Article 35 sets the grounds whereby a party can request to object to the enforcement of the arbitral award, or the reasons that a judge can, or the competent judge can refuse to enforce the award. And again, they are more or less drawn from the international standards, being the Universal Model Law and the New York Convention. And please, Dave, I will go through them, but please stop me if I'm going to get out of the time window that you would like to allocate for this matter. But again, to avoid any disturbance to the audience, they are copying the reasons for refusal of enforcement as per the New York Convention and the Universal Model Law. And that is, if one party of the arbitration at the time of the conclusion of the agreement was incompetent, or has under some incapacity under the law governing its capacity, or the arbitration agreement is invalid under the law to which the parties have agreed to apply to the arbitration agreement, or under the law of the country where the award was made, if the parties fail to agree on that. The other ground, if the party against whom the enforcement is sought was not duly notified of the appointment of the arbitrator or the arbitral procedures, or was unable to present its evidence for any reason beyond its control. The third ground, if the award has decided matters which fall outside the scope of the arbitration agreement or in excess of the arbitration agreement. However, again, following the friendly approach to the arbitration, the law opens the gate that if it is possible to separate parts of the award related to the arbitration from the parts unrelated to arbitration, it is allowed to recognize or enforce the award deciding matters within the scope of the arbitration agreement, or the matters that did not exceed such agreement. The fourth ground, if the composition of the arbitral tribunal, appointment of the arbitrators, or the arbitral proceedings was in contradiction of the law or the agreement of the parties, or in the absence of an agreement was in contradiction of the law of the country where the arbitration took place. Or finally, the final ground is the arbitral tribunal is no longer, the arbitral award is no longer binding to the parties, or has been set aside, or enforcement of the award has been stayed by a court of the country in which the award was issued, or in accordance with the law thereof. These were the grounds that a party can request the enforcement competent judge to refuse the enforcement of the arbitral award. And the same article in the law also sets the two grounds where the competent judge in his own motion can refuse to recognize or enforce the arbitral award, and like they are the well-known two reasons. The first one, if the subject matter of the dispute is not capable of settlement by the arbitration under the law of the state of Qatar, and that the recognition or the enforcement would be contrary to the public policy of the state of Qatar. There is a procedural matter that if the competent court became aware that the arbitral award for which the recognition on the enforcement is sought is subject to setting aside before the court of the country where the award was issued, he may adjourn the order of enforcement as he deems fit. In addition, the competent judge may, upon the request of the parties seeking recognition or enforcement, require the other party to provide suitable surety. In any case, let it be an own motion of the competent judge or in accordance with a request of one of the parties. In any case, the law provides for an appeal level of the decision to refuse or to enforce an arbitral award to be brought before the competent court within 30 days from the date such a decision is issued. This is, in summary, the framework of enforcement for arbitral awards in the Qatari legal system. And I'm very happy to reply to any other queries that you may have, Dave, on this matter.
Dr. Elsanbadi, thank you very much for that very detailed and thorough explanation. Particularly, I really enjoyed the fact that you went through each of the points on which an enforcement might be resisted or set aside. I think that's very helpful for our listeners. The one thing you said at the end, and I just wanted to confirm, you know, for example, in Korea, you go to the competent court, but under Korean, the way the Korean judicial system works is that either party can appeal it all the way up to and including all three levels of the court, including the Supreme Court level. And I was just wondering if you could share a bit how that works in Qatar. You did mention that at the appeal level, it would be possible for a competent court to rule on that. But at what point or at what level can a decision made by a competent judge either be challenged or appealed?
We're talking here, as you know, about the decision to enforce or not to enforce, not of course in relation to a request to void the arbitral award. And again, that is very limited in the Qatari legal system. You cannot appeal, and you cannot, of course, do any other thought apart from the standard grounds for avoidance dispute. But for that level, if the enforcement judge has issued the decision to enforce or has issued the decision not to recognize or not to reinforce, this decision is subject to an appeal in front of the competent court within the limits of the reasons for the enforcing or not to enforce. They don't go ahead and look at the merits of the arbitral award or the accuracy of the arbitral award or something of the sort.
Thank you. That was very helpful. Perhaps now we can turn to Mr. Andreaitis. Tony, what is the status of enforcement in Japan? If you could just give, you know, sort of a general overview for those in the audience that might not be familiar with enforcement in Japan.
Okay. First off, as an American lawyer speaking in this remote setting, I think it's customary that I begin by declaring definitively that I am not a cat. That needs to be stated right up in the beginning of this whole thing. Secondly, it seems that I've got some kind of a Japanese horror movie select form of camera that keeps on blurring my view. So keep in mind, this is just technology. There is no horror movie aspect to this. Thank you for the introduction. I enjoyed hearing about what's going on in Qatar. I think, you know, much as with Korea, Japan is considered to be a fairly pro-arbitration, very pro-arbitration jurisdiction. And I should say, just to show you, I'm wearing two hats now as a practitioner, as a partner at DLA Piper, but I'm also the professional institutional relations officer over at the JCAA. And so there is, I do want to promote Japan as a location, as a seat of arbitration, and the JCAA as an institution. So I just want to get that potential conflict out of the way. But Japan is a signatory to the New York Convention. They had one reservation. The reservation dealt essentially with reciprocity. Said that if the award is issued in a country that is not a signatory to the New York Convention, there is no need for Japan to be bound by that. That being said, however, there's been nothing that I'm aware of where Japan actually ever applied that reservation. So there's never been a time when Japan said, "Wait, you're not a signatory. We're not going to enforce this." So the understanding in Japan is that as long as you abide by the general rules of the New York Convention, and as you know, those rules are reflected in the UNCITRAL model law as well. So if you abide by those general rules, that's going to be the status. That's going to be how they decide whether or not an award maybe can be set aside or enforced. I know we're talking about enforcement here, but as you also know, under the model law, the reasons you can use to set aside are very similar to the reasons you can use to not enforce an award. Speaking of the model law, Japan does use the UNCITRAL model law. Japan, though, the model law, the Japanese arbitration law was enacted became effective in 2004. The UNCITRAL model law was amended in 2006. As a result of that, partly as a result of that, Japan does not use the the amended version, the 2006 amended version. They use the pre-2006 version of the model law. There was a lot of discussion right now in Japan about enacting the post-amended, the amended version. So, and there's been a lot of discussion in general in Japan about arbitration. And a lot of this has come from practitioners of arbitration, international practitioners, domestic practitioners, pushing the government. And these changes had led to some very recent changes in law and institutions here in Japan. They've recently revised the Arbitration Act, as well as the Foreign Practice Act here, with the Gaiben rule. Gaiben in Japan is the foreign practicing lawyers. So I am a Gaiben. That means that I am authorized by the Ministry of Justice to give advice on the law of my jurisdiction, which is New York in the United States of America. So one of those changes is, in general, about practice. It used to be that a foreign registered lawyer needed 2 years of practice outside of Japan, preferably in their own jurisdiction, but actually the law was not clear there. It could be a New York lawyer could theoretically be practicing in Singapore, and that would qualify as the out of Japan time. That's been reduced to 1 year. So very soon that requirement is going to be 1 year. So that's considered to be a way to encourage more outside foreign legal talent to come in and become registered. Another main change has been in the definition of what international arbitration is. So even though on the enforcement level, domestic arbitration and international arbitration are enforced essentially the same way, go through the courts in essentially the same way. And the process of, for example, if you challenge an enforcement, it's going to take anywhere between 1 and 3 months for it to be concluded. So it's pretty fast. And just like in Korea, it can be appealed all the way up, but the courts here tend to be very arbitration friendly. So what's happening now is there was a designation previously that foreign lawyers could act as counsel or as arbitrators in international arbitration. The distinction was they could not act in domestic arbitration. And there was a question about what's the distinction? What is international? What's domestic? And what happened was this came out of a very large case that I was involved with while I was at a Japanese law firm that was between the Japanese subsidiaries of 2 Europe-located parent companies. And the idea, even though there was no final court decision on this, but there was a challenge made. They was said, look, These are two Japanese subsidiaries who are the ones who are, the contract is about the contract between one Japanese subsidiary of a European parent and another Japanese subsidiary of a European parent. So that is a domestic arbitration because it's the Japanese subsidiary versus the Japanese subsidiary. So the law quickly, actually surprisingly quickly, because laws don't change very quickly in Japan, but the law quickly changed to say this kind of scenario where you have subs, international sub is now an international arbitration. So you could have foreign counsel acting in the forefront, right? So Japan has moved. Please, you had a question?
No, I was just going to say, and how quickly are we talking here? Because it's all relative in terms of, because we know laws take a long time to.
Within 4 years.
Wow, that is quick.
Yeah, 4 or 5 years. So it was quick.
That is quick.
It was quick.
That
So
is
think about it this way. There's discussion now about changing the arbitration law to reflect the amendment rules because the amendments came in 2 years after, right? 2004 versus 2006. Still no amendment. But that change came quickly. That change, and I don't want to sound like I'm being critical toward Japan because as you're pointing out, that's the similar situation in most jurisdictions. It takes a long time to change statutes. It takes a long time to change statutes. So, and this is because there's been a government effort to open Japan up to arbitration. And in furtherance of that effort, there's also been the sponsoring and the building of a Japan International Dispute Resolution Center, the JIDRC. And they have an actual physical facility in Tokyo and in Osaka. This is very important. I was involved in an arbitration where we didn't have a physical facility for a tribunal. We had to use a hotel. We used a very nice hotel. I believe that using a very nice hotel for about 2.5, 3 weeks cost about $300,000 US.
Wow, must have been very nice.
But it makes sense if you think about that. You need multiple conference rooms, you need breakout rooms. So if you have a facility like the JIDRC, like the Japan International Dispute Resolution Center, it's a much more reasonable way, and it's built specifically for a tribunal. So you keep the costs low, and you know you're looking to a jurisdiction that understands the intricacies of international arbitration. And you know, things like Maxwell Chambers in Singapore now, it's getting expensive. It's getting expensive. So it's good. I know in Seoul you have the SIDRC, which is connected to the KCAB. It's good to have these types of facilities. And later, when I'm done with this, I would love to hear what the situation in Qatar is as far as facilities and institutions, if it's a hotel thing or if it's within an institution.
To be honest, I know that time is attacking us. So for the benefit of the audience, as long as they have heard about Korea and Japan, to be honest, I think that the Qatari arbitration institutes, they have state-of-the-art facilities. The Qatar Chamber of Commerce, of course, they have their own facilities, and of course, the QFC court has like amazing facilities, and the cost is like minimal. I sit as an arbitrator in many of these facilities, and like you can really do whatever you can imagine in, like, you know, a specific meeting rooms, facilities, translation services, transcript services. I agree with you. This is a great advantage. We don't do this kind of like hotel rooms.
That's right. And a lot of jurisdictions they do. You know, in a lot of jurisdictions they do, or they rely on the law firms to provide their facilities. But again, there are cultural elements to that. Some jurisdictions, the law firms are not comfortable having outsiders coming in for a tribunal within their offices. So these are things. This is why an institution that offers the facilities are very good. Now, furthermore, the JCAA has recently expanded their rules. They have 3 set rules now, and one of those rules is appealing to civil law jurisdictions, and that gets me to something else I want to bring up. I mean, I'm delighted that I'm here on a panel now with someone from Korea and someone from Qatar, and we're from different legal traditions, be it Egypt or America or Canada, common law, civil law, different traditions. But when we're looking at Asia, and Asia's big, right? I mean, as you might be able to tell from my name, I'm of Greek descent. Basically, 3,000 years ago, the Greeks looked at everything to the east of them and said, that's all Asia. So, and for some reason, this sticks to this day, right? Asia is big. So many different cultures, so many different people, so many ways of thinking. It's an amazing continent. And I'm really happy to be living in Asia, but I understand that living in Japan is different from living in Korea, different from living in Singapore, different from living in Qatar. It's all very different. And I think in international arbitration, what's exciting to me about international arbitration is that flexibility. So I see, for example, in Asia, there's this, Singapore is great, Hong Kong is great, but there's no reason why we need to stay in that Singapore-Hong Kong dichotomy. That we can spread out, and it's wonderful to hear about these institutions in Qatar and all over the Gulf and all over East Asia, because when these institutions are built, it helps train future practitioners. And we should be looking to encourage this training. So we shouldn't look at knowledge as something we put in a jar and only let out in special times. We should look to spread this throughout Asia and throughout the world. So it's exciting to me to be here on a panel with the two of you, because it shows that arbitration is really in that position right now. And we should encourage each other's institutions to grow and to share and to cooperate. And I don't mean this as I'm taking a slight against Singapore and Hong Kong. I'm not. We can learn a lot from Singapore and Hong Kong. But as we're talking about investment from Japan, from Korea, into the Gulf, into the Middle East, into North Africa, we see situations where maybe a Korean construction company wants to have the arbitration in Seoul, right? It doesn't have to be in Singapore. Or maybe they'll agree to have the arbitration in Qatar or Dubai or Cairo. And it's important that we exchange this information to decide. Now, I know I've been talking a bit too much right now, but let me just conclude that there was a case on enforcement that really got people very concerned as of late, dealing with in Osaka, where there was a set-aside proceeding, and the situation was that someone had lateraled into a large international law firm, while this other person was a tribunal member, and that person who lateraled over had a conflict. And initially, the lower court in Osaka ruled that there was no reason to set aside. Then the high court said there is a reason, there's a conflict here. Then the Supreme Court said, okay, the high court kind of got it right, but we need more information to find out, did this guy know about the conflict, and did the law firm know that there was a conflict? So they basically said, we're going to have to look into this more. A lot of practitioners here in Japan became very concerned. Oh my God, what's this going to do? It's going to discourage people from going to Japan. I wasn't that concerned, because this kind of issue of conflict is an issue that comes up in the States pretty often. And as we often see, I don't know if any of you have experience with American law firms, they have very, very, very advanced conflict check facilities in place for exactly these types of things. So as is often seen, sometimes America takes the leadership point on a change in a profession, and then little by little other law firms around the world start to implement this. So I think the case is just basically saying that what, to me as an American, is common sense. Take conflicts seriously. So I don't think it discourages Japan in any way as being a good seat for arbitration. And if anything, the Supreme Court just said, let's look into it deeper, let's get the facts, I think is a very reasonable decision. And I think in most jurisdictions, if you had this kind of potential conflict, the courts would be concerned. Okay, I've said what I need to say, and I pass the microphone to the two of you gentlemen.
Tony, thanks so much. There's so much to unravel there, but given the limited number of minutes we have left, I thought I would just comment briefly on that Supreme Court case you mentioned. So it seems like it was punted back down to the appellate court. So I assume it's currently at that stage right now, or?
Yeah, I don't think there's a final decision. I don't think it's been formally set aside yet. I haven't looked into it. If I find anything, I'll update the group. But My only point was that it's not as big of an issue as some practitioners are trying to make it. I think it's very reasonable. Yeah.
That's a relief. And Dr. Elsanbati, just back to you. There was a couple things that that Tony had raised, and I think they're valid points. You know, when as an arbitration lawyer that's been in the sphere for over a decade, you know, I only started first hearing about the DIAC, you know, a few years ago, 5, 6, 7 years ago, and same with the QICDRC. And so there's probably no better person in this panel or the audience that has seen this, you know, from a first person's point of view, to see it grow and develop over the years. And I just wanted your thoughts on sort of the arbitral institutions that have formed and have done quite well, and they've done extremely well, and they're very sophisticated with their rules. And I just wanted your thoughts on that as well in terms of the Qatar and the MENA region.
Sure. Thank you again, David. And yes, I would like to stress on this. We will talk about some few matters as Tony has done in relation to the Japanese legal system and so on, where we have to be careful when we are running our arbitration. And this is like a common sense for sure. You have to be careful about the procedures. You have to be careful about all the small matters that may interrupt all the amazing work that everyone in the arbitration is trying to do. However, this doesn't undermine, to be honest, the clear intention from all the stakeholders in Qatar to push forward the arbitration agenda in the state. As I told you, I would believe that the 2017 law that is available in all the languages now is very advanced. It satisfies most of the requirements of any practitioner. You can see that there is a very clear tendency in the courts to support arbitration. The law itself was very careful to limit the intervention of the judicial system within a specific panel that is specialized, well prepared, and qualified to do so. Practitioners are being more sophisticated. You will have lots of events, including such an event that adds to the knowledge base in the arbitration practice. You see that there are many foreign law firms are operating here, covering the corporate practice and to a large extent the arbitration practice, and all of this adds to the knowledge and to the competencies in the state. Speaking about the institutional arbitration, we have the Qatar International Arbitration Center. They have a very good number of cases. They have qualified staff. They have good facilities, and they are like evolving as the time go. And we have the institutional facility of the QFC court. They have a good arbitration law. They have also very clever, competent court and enforcement judges. So, like, I think as I was saying, the future is bright, and there is all the good intentions of the stakeholders and serious contribution by the state, by the courts, by the legislator, by the institutes to make it a success story. The only things that we have to be mindful of is, and I would advise any practitioner, be careful when you start your arbitration or you draft your arbitration clause. Make sure that you just refresh and update your knowledge about the situation from a qualified person from on the ground. So you are 100% when you put the arbitration clause that it is correct, covering all the aspects. And if the time will come to start an arbitration procedures, being an arbitrator or like a lawyer in front of the arbitral tribunal, be sure that you are diligent in following all the correct procedures, from seeing the case, hearing the witnesses, awarding the award, and all the procedures that are should be taken into consideration on a day-by-day basis. Like, for instance, there was that case that is famous, and now I think many people are aware of it and trying to avoid this kind of things. There was like a decision that was issued at some point that any award that is issued by the state should be issued in the name of His Highness the Emir, being the head of the state. And lacking this would create some vagueness in interpretation and so on and so forth. Again, I think the decision was not repeated in other enforcement cases. However, now I would advise anyone, as myself doing now, I put that the award is issued in the name of His Highness. For instance, like this kind of small things that we learn by the time and we try to be careful about. And it doesn't, as Tony has said, it doesn't show any intention of any stakeholder in the entire regime that we want to undermine arbitration. However, there are things that happens in any judicial system, and we have to be mindful of and make ourselves and other practitioners aware of to make sure that we have a successful story when we get into like any related matter to arbitration.
Dr. Elsenbadi, thank you so much. That was very helpful, and the practical aspects that you shared with us. And I think it just goes to show, and perhaps we'll wrap with this, is when you have the support of the state and all the stakeholders, and you have this this unified sort of push to grow and support arbitration, and we've seen it in Korea, Japan, and Qatar, I think that only bodes well for the future of arbitration and future dispute resolution. And on that point, unless there's any other comments from both of my fellow speakers, I just wanted to thank Legal Plus and this opportunity for us to hear from both Tony and Dr. Elsenbadi. And this concludes the last session for today. Thank you.
Thank you very much.
Thank you.
Well, honored guests, we must now bring the 6th Annual Legal Plus Virtual Arbitration Summit to a close. I'm sure you have been as enlightened and informed as I have been. Of course, this great summit would not have been possible but for our generous sponsors, the QICDRC, Charles Russell Speechleys, Dialis, HKA, BakerBots, K&L Gates, and LexisNexis. I thank all the speakers for their excellent, practical, and timely advice and tips to make our dispute resolution more efficient and effective. We have heard how the processes and participants in arbitration are evolving and improving to meet our needs. For example, as Christopher said, how mediation could improve our dispute resolution. Jay's grand panel gave us inspiration in the ways that disputes can be resolved both quickly and fairly. Funding, a vital part of the process, Patrick gave us much food for thought. We have heard how dispute resolution centers, such as the QICDRC, are looking ahead with Dr. Zane's assistance. Experts, Phil enlightened us on how best to utilize them. Dr. Rula helped us decode post-M&A disputes. Lastly, David's panel updated and enlightened us on the crucial stage of the enforcement of our awards, the fruits of our labors. So with that, I wish you goodbye and thank you very much for participating. And please look forward to next year's 7th Annual Arbitration Summit in Qatar. Thank you very much.